Matter for by the give. It is at which serial? It is at which serial? It is pending at which serial?
Item number 01.
01.
Item number no, it is not.
Not on list. It will first give. Let it be included. Then you mention. Take it. Give the inclusions. Anybody wants the inclusion? You give it.
My lord, may I mention, my lord?
The matter for upgradation, my lord. So, compassionate appointment form 2022. It's pending, my lord.
Yes, you are not alone, sir.
My lord, may I be permitted to mention this matter? It is a pension terminal benefit matter, my lord. Since 2021, it is pending, my lord. The 2007 legally terminated, my lord. The wife of the deceased employee, he has his bedridden condition, suffering from cancer, my lord. My lord, this is your lordship. Kindly takes up this matter. It will take not more than 5 minutes.
So, what is the benefit which is due to you? What benefit is due to you?
That I cannot follow you.
What is the terminal benefit which has been?
That is the our unleave salary and the gratuity amount.
That has not been paid.
Not been paid till date.
There is that.
The
That has.
termination was done by at the age of barge of retirement when the deceased employee.
We are not hearing the matter on merits.
Yes.
The withholding is by virtue of a punishment order.
Yes, termination.
Then that has to be looked into.
The termination order, well, that's why it should be looked into, because
We'll see.
it was not the opportunity of it was basically
Obviously, every matter which is pending,
justice was violated.
every matter which is pending, it is from.
It is item number 156, my lord.
Then you are
It is
fortunate. It
item
will be
number
taken up.
156 to 200. It is running for 5 months, my lord.
We'll
That's
see.
why my lord
We'll see.
mentioned.
We'll see.
Otherwise, I am not mentioned.
We'll see. All those matters are pending. We can't pick up one case and give it any precedent. We are not going to do that.
Urgency is that the wife of the deceased employee is in the bedridden condition. He hand to mouth without.
To file an application annexing all those documents, we'll consider. Yes.
To mention one matter, this is one contempt application against the Honorable Justice Harish Tandon and Honorable Justice Proceedings Vishwas. Your Lordship, Honorable Justice Harish Tandon is not available right now. This matter has been assigned to your Lordship, to a bench decided by your Lordship and Proceedings Vishwas, your Lordship. If your Lordship find this is assignment order annexed.
Since you are going to sit on file. Right, you leave it, we'll see. Yes.
My lord, may I mention, my lord? My lord, it's a contempt application. Petitioner is specially able person. This bench has passed order, the solemn order dated 11/12/2024. That is not complied. My lord, petitioner is going to retire in this year only, in December. I'm praying for
What is the direction?
for promotional posting and benefit of the promotion since 29/9/2021. That is not complied, my lord. Praying for inclusion.
Give inclusion, all you give. We have told you all inclusion you can give.
May I be permitted to mention, my lord?
Yes.
You may recall, my lord, the Dr. Ashok Kanti Sandal matter, where I and Mr. Partho Ghosh is appearing before, prior to the vacation, my lord, whereby the challenge is here, my lord. The incumbent is challenging the parity in respect of the order passed by the, my lord, by the Supreme Court, along with, my lord, the Allahabad High Court, my lord. That matter is lordship has directed to come, my lord, after vacation. What happened, my lord? My lord, in the planet cat, my lord, there is a contempt application fixed on 16th. And AS is appearing in this matter, my lord, kindly fix on, my lord.
So it is fixed on 16, you file your reply, we'll see what is happening.
Already filed, my lord.
In the CAT, what will happen on 16?
This is the contempt application, my lord, prior to, my lord, 2 days.
So at best, you will be required to file a reply. What is that?
Kindly, my lord, fix it, my lord, within day or two, my
If
lord.
there is some precipitory action taken in the contempt, then you mention.
No, my lord, kindly, my lord.
Merely because a date has been fixed in contempt, therefore it should be taken up.
My lord has my lord, directed in the order, my lord, the matter will come up.
Then it will come. Why are you mentioning?
My lord, my lord,
If there is a direction, it will come. Don't worry. Just give the case number. How many times you will say the same thing? How many times? You can keep saying it all day. You have already said, and we have already said, merely fixing a date in the contempt does not give rise to an urgency. What is the stage? Whether any action is being taken? You file. How do you know that the court will proceed further? Maybe tribunal will accept your reply.
my lord,
We don't know.
My lord, may be permitted to mention a matter with the leave of my lord Justice Bhattacharya. My lord, this is a contempt application, my lord, and Honorable Justice Vibhash Ranjan there against a matrimonial judgment, my lord, where my lord had directed the husband to 50,000 rupees per month, but not a single amount has been paid till
It has been passed by which bench?
my lord Justice, your lordship and Vibhash Ranjan, the Honorable Justice Vibhash Ranjan.
Give it.
And my lord, another matter for inclusion assigned.
My lord, may my lord, may
My lord.
Give all inclusions. Don't mention.
my lord, may permit to mention, my lord. My lord, in this matter, the review application has been disposed of by the Honorable Division Bench, presided over by the Honorable Justice Devanshu Bosak and the Honorable Justice Shabba Rashidi, with a direction to the department to place the main matter before the regular bench in the monthly list of April. But my lord, the same has not been listed in the monthly list of April.
But what has happened?
The review application has been disposed of by the Honorable.
There is a direction for placing before the regular bench.
Yes,
Then what happened?
But the matter has not been listed, my lord.
To give it, we are saying give all the inclusion. Why are you not giving?
My lord, with the lordship leave to mention this matter, my lord. My lord, there is no order. My lord, I moved the tribunal, my lord, on 9th. My lord, as a 14/6 is the date by which I have to upload the NOC for participating in the selection process, my lord, to be conducted by AIMS New Delhi. Now, my lord, I approached the tribunal. My lord, tribunal has fixed the matter before the registrar bench on 11th. My lord, that's the reason I moved the, my lord, officiating chairman, mentioning the matter, my lord, it cannot be taken up by registrar bench as because registrar bench cannot have authority to pass any interim order or any other thing, my lord. That being the situation, my lord, the tribunal refused my prayer, my lord. My lord, I am practically, my lord, if my matter is not been taken up prior to that date, my lord, 14th, my lord, entire thing will be infructuous. My lord, that is the reason, my lord, I'm praying before lordship, my lord, leave may be granted to move this application without any order. My lord, I will be placing an interim order. If your lordship grants me interim order, I will be limited back to the tribunal, let the tribunal decide. Your lordship has decided the issue of NOC, my lord. Nothing is there still, my lord, I have to face this.
How do we know what you are saying is?
My lord, I've annexed, my lord, I've annexed all those documents, my lord.
What documents? You have annexed a filing proof. How do
Yes,
we
ma'am.
know that you have mentioned it has not been allowed and everyone can come and say the same thing?
Well, I've in my petition, my lord, I made an averment to the extent, my lord, that I mentioned. In averment portion, my lord, I mentioned that thing. I mentioned the matter before the learned
Yeah,
tribunal.
how do we know? How do we know? There must be a mentioning slip. It must have been accepted. What have you given? Therefore, we are saying everyone can come after filing an application before the CAT that you give a direction.
My lord,
We don't want to start
Lord,
this.
my lord, your lordship kindly take note, my lord. Subject lordship kindly leave. My lord, what I'm beseeching is this, my lord. I mentioned the matter, my lord. I personally mentioned this matter, my lord. I'm not saying anything, my lord, which is not there. I was there myself, my lord. My lord, I
So
mentioned,
tomorrow it is fixed.
my lord, before the registrar bench.
So you ask the registrar to place it before the bench day after tomorrow.
No, my
What
lord.
is the big deal?
My lord, I have to serve copy, my lord. 48 hours notice would be problem, my lord.
Who is stopping you from doing that?
My lord, if tomorrow the matter is placed before the registrar bench, my lord.
You could serve today. You could mention before the registrar tomorrow that you place it before the bench next day. Why the High Court has to take it up?
My lord, the registrar bench, my lord, your lordship, my lord.
There are still 3 days left. We will presume that it will not be taken up till 14th. Then why not every case first come to the High Court and then go to the CAT? Please try to understand what we are saying.
That's true, my lord, but your
We
lordship.
we can't open this kind of a floodgate. We don't want to.
My lord, in that
We
situation,
could have
my lord,
understood that after registrar it has been rejected, a date has been fixed after the 14th in spite of file a slip tomorrow. Why should you
as-
presume that nothing will
as
happen?
your lordship. Tomorrow, my lord, if nothing happens, my lord, I will
Then
mention.
you come back, yes.
And by me, I am in person and Chief Justice. High Court signed this matter. My lord, I submit the supplementary evidence to court on assignment. Then sending this matter.
Yes, it will come. What is the case number?
Sending this matter to.
Give the case number. Let it come on the list.
Event 1806 of 2024. सब लिखा है।
स्लिप पे लिख के दे दीजिए।
You give the case number. It will come on the list. It will come on the list. Then you file it. देंगे तो Monday को लगा दे. Monday. Yes.
My lord, make a one
You
indulgence.
tell him. See, it will come on Monday. You please tell him.
My lord, may I make a kind indulgence, my lord? My lord, tomorrow the matter is placed before the registrar bench. In the morning, it will be taken up. If my lord, leave me granted to mention the matter at the 2 o'clock before.
We don't know.
Yes, my lord.
At the moment, we are not going to say anything. You are a lawyer. You know who is stopping you. You can mention at 8 o'clock in the night. You know, or for urgency, the High Court is available 24 hours. Yes.
May be permitted to mention an assigned matter, Your Lordship. This is a probate matter of 2021. Uncontested matter, my lord. This is an appeal, Your Lordship. The petitioner is suffering from various ailments. Lordship, kindly includes the matter, my lord.
It's an assigned matter.
Assigned matter.
When? Any? Take.
Pardon me, my lord. I am getting only one mentioning slip.
Assigned.
My lord, kindly take the last page, my lord.
Where
That's
is the
the
assignment?
last order passed by this court.
Verify if it is assigned, then otherwise. Yes.
Great. Obey that.
Be in contact with the court officer.
My lord,
He will inform you.
deeply obliged.
Item number 5.
My lord, in this matter, my lord, I appear virtually for the Petitioner Union of India. Lord, this is a matter, my lord, identical. Another matter is there. Both the matters are admitted. Now, Lord, we are facing contempt before the tribunal. Lord, both the matters, my junior is before your lordship physically. Lord, he will give the slip before the court officer. Lord, let both the matters, Lord, appear so that we can get both the matters disposed of. Or Lord, we can pray for an interim order so that contempt cannot be proceeded.
No, when is the contempt? What is the stage in the contempt?
Lord, the date I cannot give your lordship the date right now.
You are required to. Otherwise, why should we unnecessarily keep these matters?
No, Lord, both the matters may be disposed of. This is admitted matter
Every
of
matter needs to be disposed of. But you are giving an urgency of contempt. Therefore, we are asking you.
Lord,
What
we
is
have filed one application. Lord, your lordship kindly have
Start.
a,
We'll dispose it off. You can argue.
Lord,
May we just get a copy of this application? I've been instructed to appear on behalf of the respondent. It is not served up.
Lord, we have filed one application for interim order in connection with the main matter. Lord,
You have
saying
filed
that
application for interim order.
Yes, yes. Lord, that is Can 1. My junior is present before your lordship. He would definitely, Lord, assist your lordship with regard to the application when it was filed, Lord, whether it was served upon the respondent or not. Everything would be made clear to your lordship, Lord.
You are appearing in the other matter also. He says that two matters are to be listed.
Yes.
But I have been
Yes, in fact-
instructed to appear, my lord. I do not even know what is this matter about. We are not served with any of the copies which have been filed before this honorable court.
But you don't have power today.
I do not have even the copies.
No, unless you
But
have
the-
power, how it will be served on you? Have you filed a wakalatnama? Has anybody filed a wakalatnama?
No, my lord. But is this a contempt? I'm sorry, my lord. I'm asking this question to myself. Is this a contempt petition?
No, this is a WPCT.
But I am verbally I am instructed to represent the respondent.
Therefore, we are asking you whether they are to serve copy on you or not.
No, my lord. Let them. Yes, I could be served with the copy because I have been orally instructed. I am sorry, I could not get your lord.
Have you filed a wakalatnama?
I did not, I
If you have filed, then you can take the copy.
I did not. I did.
Otherwise,
I did. I did. I did.
will you file it today?
But my client did not come to the court today.
Can you file it? When can you file?
Possibly, my lord, day after tomorrow. Day after tomorrow, not possible.
So you
Day
give
after
a
tomorrow.
copy. Mr. So-and-so, Learned Counsel for the And which is the other matter that he is saying has to be listed?
That matter, my lord, 205, my lord, that is not in the list matter.
So let this be taken up on Monday, then we'll see.
But let both the matters be taken up on Tuesday, my lord, instead of Monday.
No, we are keeping it on Monday.
Lord, I have some difficulties, if your lordship kindly
All right,
consider.
Tuesday.
Yes, I am extremely grateful to my lord. Both the matters.
The other
Extremely-
matter, we don't know if anybody is representing the
My
respondent.
junior
Why
would
do you
give the slip to the court officer immediately. My junior would give the slip to the court officer immediately.
please try to
respond.
listen to us for a second? Was somebody is representing the respondent in this matter? Let this be taken up on Tuesday. We'll see if that is required to be done. Yes.
All right. I'm extremely grateful to my lord.
Great.
Extremely.
Item number 6.
My lord, item number 6, I am for the petitioner. I am being led by Mr. Nilanjan Bhattacharya, senior advocate. He has some personal difficulties, so he has requested me to pray for a day's adjournment.
Not today.
My lord, I appear for the respondent number 1 and
Yes,
2.
not today. Let him come.
Very well, my lord.
Yesterday also it was adjourned. What is the matter? You have no, you don't want to proceed with the matter.
But I don't think this writ is maintained. It's a 226 application.
He has spoken to me. We have spoken over phone.
Yesterday also it was adjourned, sir.
You understand, my lord?
Every day you want an adjournment?
Tomorrow, my lord, it will be done. Tomorrow.
Yes.
Very well. Seven.
I appear to see lordship.
Under-
I am for the. I want to use a supplementary affidavit, my lord.
No, first you proceed, then we'll see whether supplementary is required or not.
It is, the petitioner is my lord, the unmarried daughter of a deceased employee, my lord, who is died in harness, my lord. Now, my lord, the case was that the petitioner was not paid for, my lord. The petitioner was, my lord, made nominee in respect of, my lord, all retirement benefits, and my lord, including the, my lord, the family pension. The petitioner was applied, my lord, the family pension and retirement benefit. The authority, my lord, was decided in 50% of the, my lord, the family pension in the favor of the petitioner, who is the unmarried daughter of the, my lord, the deceased employee, and 50% of the second wife. And with regard to, my lord, retirement benefit, my lord, that was only petitioner, since he is a nominee, my lord, the authorities have decided, my lord, to disburse the amount to the petitioner. My lord, since no payment was made, my lord, we have filed an application before the, my lord, tribunal. The tribunal held that no, this is with regard the payment was made, my lord, to all the legal heirs. My lord, that is the, my lord, the whether, my lord, the nominee is entitled to, my lord, your lordship is no, my lord, the nominee is the custodian of the amount. Tribunal orders are challenged fully. They can challenge tribunal reason the lawsuit is huge. Petition is the অসুবিধা তো কি হচ্ছে? But আমি আমাকে ডকুমেন্টস পাঠিয়েছি, এটা কিছু করছে, এটা তো আলাদা, এটা তো আলাদা। as per article সেগুলোই আমার যদি একটা কিন্তু ডিসিশন না নিয়ে তো আমাকে অর্ডার পাস করে দিয়েছে, আমাদের না তোমার সবাই ডকুমেন্টস সেটা কল করে, যেটা তো ট্রাইব্যুনালের অর্ডার কোনো ভুল নেই, তাহলে তাহলে ওদের ট্রাইব্যুনাল অর্ডার কোনো অর্ডার অর্ডার চেঞ্জ করে দেন। আমি ট্রাইব্যুনাল অর্ডার আমার রিজন অর্ডারটা কেউ চ্যালেঞ্জ করেনি, ট্রাইব্যুনাল সেই রিজন অর্ডারটা কিভাবে ইস্যু করে, কি করে তুই কিছু জানিস না কেন করি না?
And who are you?
I am the unmarried daughter who have been made nominee in
Unmarried?
unmarried daughter of the deceased employee.
What is your name?
Mampi Bhattacharya.
So they have directed to give you 50%.
So, my lord, the direction was tribunal, my lord, with regard to direction, my lord, the tribunal was directed to take a final decision.
No. Take a final decision in terms of what has been stated.
My lord, that is, my lord, with regard to 50%, my lord, I have no issue. My lord, because my lord, there is a second wife, my lord, whether the second wife is entitled, my lord, because during pendency, my case was during pendency of the during my the life subsisting of the first wife, my lord, the second marriage was, my lord, solemnized. My lord,
That you can move the civil court. Nobody is stopping you.
and my lord, with regard to, my lord, the retirement benefit, my lord, your lordship is not under the DCI's rules. Nominee is the custodian of the entire amount.
What nominee? There is no nomination.
Yes, my nominee was made, my lord.
There is no nomination.
Faulty nomination,
There is no nomination. It was never accepted.
The unmarried daughter was
It was never accepted. Don't say that there is a nomination. The nomination was never accepted. The tribunal has said that there is no nomination. Therefore, we are apportioning it among these persons in this way. What is wrong?
Exactly.
If you want to get any order from a civil court
No.
Declaring the marriage void or something, then you can get it.
No, you'll also kindly take trouble to, my lord, the reason order passed by the authority.
Yes, let us see.
That
Page.
Page 21, my lord.
it is the same thing which is recorded in the
Come
tribunal.
to page 23, my lord, the second paragraph, my lord, from the bottom. In view of above, we start from in view of above, my lord. In view of above stated facts, Director River Research Institute West Bengal or pension sanctioning authorities hereby requested to accept the nomination papers submitted by the ex-employee Rajiv Bhattacharya during his service life and all the death and retirement benefit, namely death gratuity, general provident fund, and group insurance leave salary may be disbursed to the Mampi Bhattacharya, nominee of the ex-employee Rajiv Bhattacharya. My lord, the authority is held, authority will accepted the issue with regard to my lord, the nomination of the Rajiv Bhattacharya.
That is not the conclusion, sir. That is something which
The
has,
order, one kindly see the
that
order.
is something which has happened in the meantime. That is not the conclusion.
Now, my lord, conclusion page 25, my lord.
Yes, now come to the conclusion.
Yes,
Don't
no,
just
page
pick out
25.
one line and say that relying on that we have to pass.
Page 25, that is the
It
conclusion.
is the same which the tribunal has said. There is
No,
no
my lord,
difference.
with regard to my lord, paragraph number 2, my lord, kindly come to paragraph 2, disbursement of death come retirement benefit. The director, River Research Institute West Bengal Pension Authority is hereby requested to accept the nomination papers submitted by the ex-employee Rajiv Bhattacharya during his service life. All the death and retirement benefits, namely death gratuity, general provident and group insurance, and leave salary may be disbursed to Mampi Bhattacharya, nominee of the ex-employee Rajiv Bhattacharya.
So why have you challenged the order then?
No, we are not challenging the order. We challenge. We have, my lord, in terms of this order, they have directed me to produce certain documents. My lord, my mother was died when I was minor. But I could not produce the document of my mother death certificate. Now, my lord, with regard to burning certificate, I have been, my lord, produced because my burning certificate. Ultimately, my lord, tribunal is accepted that it is a special case, and you accepted the burning certificate of the petitioner's mother. My lord, that is why, my lord, to that extent, my lord, I file application before the tribunal. Because the requirement documents which is
But the tribunal has already said that it has to be accepted. Then why have
that was been accepted, but in contrary, my lord, he has been, my lord, reversed the observation of the authority, my lord. Because the authority has says that the nominee is entitled to get entire benefit, but the tribunal has said that no, all the legal heirs is entitled to get the benefit. That is the contradictory, my lord, with regard to my authority and my lord, the tribunal.
final decision has been taken?
Not yet, man.
So if that goes against you, then you can challenge it. We don't know right now what they will decide.
In terms of observation, the final decision was directed to be taken. That is why, my lord, I come before your lords, my lord. That is, my lord, nothing else, my lord.
Lordship, he's challenging the order of the OA case that he has filed. Lordship, if I may make some submission on behalf of the state, and to assist your Lordship, I have prepared a report which gives a statement of facts in sequential order, stating exactly what happened when. If Lordship would be kind enough to accept this report, then I can make my submission.
If you want to file, you have to file
I'm filing this
affidavit in opposition. What report is to be filed?
just a statement of facts in the
Why
form
that
of
statement of facts is to you for preparing an affidavit? That is a privileged document. Why should we take it?
fine, Lordship. Then let me just make my presentation as per my
Yes.
report that I have. Lordship, what happened was the petitioner's father was an employee, a Group D employee who passed while he was in service. After that, he submitted his nomination papers. However, that was a faulty nomination paper because it was not countersigned. On one hand, in that
Just give us a minute. Disagrees with the second part of it. So that issue notice. And this order, speaking order, did the others participate in this?
Before the my lord, authority, my lord.
Yes.
No, my lord, they are not attending.
Then how their rights can be decided in their absence, sir?
In spite of notice, they have not been come, my lord.
We don't find that.
And the petitioners claim that the second marriage is void, cannot be.
The official letter issues to the private respondent was 678 with the request to attend the hearing.
Where is that stated? Show us.
My page 21, my lord, kindly come to page 21. Reason order, my lord. Paragraph number, my lord, it start from Soma Mondol, my lord.
Soma Mandal.
Yes, start from our type private respondent 6, Arindam Mukherjee, Koyal Mukherjee did not attend the hearing conducted on 21st of September 2022. In this matter, the official letter issued to the private respondent with request to attend were returned back to the office as they refused to receive the official letter.
Respondent number 7 appeared. Just before the start of the hearing, he has come. He has been served with a letter and he says then he did not appear. What he will appear? If he has taken the letter, a date should have been fixed after a week. Otherwise, how he can appear? Before the hearing, some have given the letter and been decide. Maybe 6, 8, 6 and 8 only. Read further. Just before the start of hearing, so he has come at the time of hearing. He must have been that on today. Yes. What letter he has taken. Sufficient 6 after 5 days, 7 days after. But you are taking the letter today. So, 5 days whatever. This is not sufficient. Can be this is recorded. How you proceeded? When he has received a letter just before the hearing, what was the
refused, my lord? Initially they refused. They are told we are.
So initially you will keep saying initially refused, initially refused, initially refused. But he appeared just before the hearing. He came to the office. Somebody must have told him that, look, we don't know. There are 3. 2 have not turned up. 1 has come just before the hearing. The authority says, take the letter, and he proceeds. This is sufficient compliance with natural justice. This is sufficient opportunity given to state his case or to participate in the hearing. Heaven was falling. It could not be fixed in the next week.
Subject to correction, he can pay for some time. I am not used.
You are relying on this order. Therefore, whether this order is sustainable, that we are required to see. An order sans the compliance with principles of natural justice. Should we consider this as to be deciding the rights of respondent number 7? 6 and 8 maybe. They did not appear. They did not receive the notice. They never turned up. But 7 had appeared. How the authority has proceeded like this? If right now some lawyer comes and says, I am representing this respondent, what we will do? You give a copy, we'll fix a date. This is very normal. We'll not say, all right, he has come, proceed.
But they have not challenged this order, my lord.
It is before us, sir. An order in compliance, in violation of principles of natural justice. And you want to base your rights on this order. And the non-compliance is writ large at the very beginning of the order. Therefore, we are asking, how this can be a valid order for respondent number 7? 6 and 8, we don't know. Have you pleaded them before the tribunal?
Yes. Yeah, and also before your lordship.
And the tribunal too, it was disposed on the first day.
No, the matter was taken on prolonged hearing. They are appeared, my lord. through before the tribunal they
They
appear.
have appeared,
Yes.
all of them.
Respondent number 6, these gentlemen, this respondent number.
Respondent number 6 was respondent number 7 there before the authority. Who was respondent number 7 before the authority?
Respondent number 6 is the Arindam Bhattacharya before the six, Suma Mondal. Suma Mondal, six. Respondent number 6 is the Suma Mondal, who is the second wife.
She has appeared before the tribunal,
yes.
but we don't find any appearance.
Kindly come to the last page of the order dated, the order number 2 dated 22nd of May 2024.
Hmm?
The page, page number কত?
For respondent number 6.
My lord, the in the order, my lord, also reflect, my lord, with regard to his, my lord, the
So respondent number 6 has also said that he filed an objection.
but he has not
7 has appeared before the authority.
but see, he has not filed any objection ultimately, my lord, in spite of direction.
What is this? How the authority is proceeding and how the tribunal is proceeding, we don't. It seems as if everybody is in a rush. Both had appeared. 6 has also filed an objection before the authority. Consistent. Order is also without data. Serve notice on the respondents. Let notice be served on the respondents.
Okay. 24. Grateful, Lordship.
If you want, you can file an madam, you can file an opposition. It will be open to the learned state council to file an affidavit in opposition.
Item number 8. And item 8, my lord, I appeal for the petitioner. Well, I appeal for the petitioner. This is the affidavit of service. Well, challenging the order of the learned tribunal, well, dated 21st of April 2025, I move the state petition, my lord.
Yes, so what is the relevant provision? Let us see.
Yes, my lord, your lordship takes up the, my lord, the provisions of the memorandum.
So basically, you are urging two grounds. The suspension review committee was not chaired by a competent authority. And secondly, you say that this enhancement of 75% already took place about a year back. Therefore, there is no decision taken. These are the two grounds. Let us
Kindly
see.
see page 67.
Your lordship,
Page 67. Review
Just
committee.
wait.
no, your lordship takes up the memorandum of the government, that is page 59.
No, let us see the rule.
Rule, my lord, that is the memorandum which I'm banking on, that is page 59.
No, there is no rule governing the civil services classification control appeals.
There is a rule,
These
my lord,
rules
there is a rule.
applicable.
West Bengal.
Conduct rules
No,
1959.
my lord, there is a rule, my lord, the WBSR 71.
So let us see the memorandum and all, they will not supplant the rule.
Yes, my lord.
Ultimately, the rule has to prevail. So what is the provision in the rule?
My lord, the rule says, my lord, if your lordship takes up WBSR,
These memorandum are issued in to supplement the rule.
absolutely, my lord.
So they will not in any way deviate or run contrary to the rule. Let us see the rule.
Yes, my lord, your lordship. Yes, sir. Yes, sir. Patwana, sir. Sir, yes, sir. Patwana, sir.
All right, you want to rely on memorandum, show us.
My lord, if lordship takes up the memorandum, my lord, at page 59.
Yes.
My lord, it starts with, my lord, the rule has been quoted. Note to IIIA below rule 71, sub rule 4 of West Bengal
West
Service.
Bengal service rules.
Yes,
So
my lord.
this must be containing the provisions.
Yes, my lord. That is the rule, my lord. WBSR part 1. My lord, note to IIIA below rule 71, sub rule 4. Now, my lord, if your lordship takes up,
It is a deemed suspension or suspension based on charge memo.
my lord, it's based on, my lord, initially I was a charge memo was issued, I was not suspended. Thereafter, additional charge was, when the additional charge came, my lord, I was placed under suspension.
So there is no arrest or anything.
No, my lord, no criminal cases there, my lord. Now, my lord, your lordship takes up, my lord, this memorandum, my lord, subsistence allowance granted to an employee under suspension, as well as the substantive question of suspension within 3 months from the date of suspension or deemed to have been placed under suspension. It has come to the notice of the government that though the subsistence allowance granted to an employee under suspension is reviewed by the competent authority within 3 months from the date of suspension, as a matter of course, the substantive question of suspension remains unreviewed. Now, my lord, your lordship may take care of two. After careful consideration of the matter in its all aspect, the governor is pleased to constitute the following review committee, comprising of following members of the review the subsistence allowance granted to the government employee while under suspension, as well as review of the substantive question of suspension. Now, A may not be relevant to me, my lord.
A.
2A may not be relevant. 2B is relevant in my case, my lord. Next
B.
page. B. 2B. B for Bombay, my lord. Page 60 at the top. My lord, review committee in case of considering suspension of government employees whose appointing authority is subordinate to the governor. My lord, I am an inspector, my lord. My appointing authority is Inspector General and Director General of Police, West Bengal. My lord, it says, my lord, the chairman would be the principal secretary, cadre controlling authority. My lord, the member secretary is the controlling authority, the disciplinary authority of the suspended government employee. My lord, the deputy secretary, deputy director of the concerned department.
This is of 2012.
Yes, my lord. This is the last only suspension memorandum issued by the
So
government.
whether it is in accordance with this provision in the rule or it is in any way contrary to the rule.
My lord, rule says, my lord, the rule says first review. That only says a few lines are there in the rules. I recall the rule, my lord. It says not only the question of subsistence allowance, but the
This constitution of a committee.
Yes, ma'am.
Does the rule provide this power to this authority to prescribe the review committee?
Right.
And it is sacrosanct or there is some other provision? What is the provision?
He is a inspector of police.
Yes.
West Bengal Conduct Rules 1959, Rule 4 and 5 is applicable. But if there is a interchanging, then West Bengal service class, this service rules may be applicable. Number one, according to the notification issued annexed by page 67, the review committee was headed by Additional Director General of Police, Law and Order.
That is what he complains. He says B requires that it should be chaired by the principal secretary or a secretary.
Or by the cadre controlling
or the cadre controlling authority.
And now power has been delegated.
Where is that?
No, I shall produce that notice.
That's because
and why it has remained 75%. We want for myself, please show the rule. I want to see what is the provision for once.
Yes, sir.
Normally, the suspension is enhanced after it is pending for 90 days and then again there is a review. In some rules, they say provisional pension 100% is also granted if there is inordinate delay.
I'm extremely grateful to my learned friend, my lord. Now your lordship will get
Rule 71
III review.
review.
IIIE. My lord, the middle portion of the book, my lord, your lordship will find. Rule 71. Rule 71. Rule 71(4). Note to III. But it says a review of subsistence allowance shall be made before the end of 3 months from the date of suspension. This will also give an opportunity to the competent authority to review not merely the subsistence allowance, but also the substantive question of suspension.
So what is your date of suspension?
My lord, my date of suspension, my lord, is I'm just coming, my lord, my date of suspension. My lord, if your lordship takes up, my lord, page.
Just give us the date.
Yes, my lord.
Definitely. One
My lord, 15/7/2024. That is, my lord, lordship will find page.
So in October, it was required to be reviewed.
Yes, my lord.
And when this review has taken place?
My lord, this review took place, my lord, in terms of the tribunal's earlier
In
order.
March.
My lord, in the
In
month of-
March 25.
Yes, my lord.
On 13th March.
13th
13th of March 2025. So how do you say earlier it was enhanced to 75%? If
Well,
this is the
that is-
first review,
Well, your
First 3
lordship
months,
takes
it
up,
will get 50%.
lordship takes up the
After 3
minutes of the
months,
meeting.
6 months, it will be enhanced to up to 75%.
Lordship takes up
Then, my lord,
67
90%
minutes of the
first he will get 50%.
50%.
Yes, my lord.
That is the subsistence allowance.
Substance allowance.
It becomes 75 after how many months?
After 6 months.
3 months.
No, after 6 months. But initially 3
What
months.
is the provision?
My lord, that
Which provision?
My lord, if your lordship takes up, my lord, that very book, my lord, your lordship has seen the first review.
Yes.
And my lord, near after, my lord, B, the second and subsequent reviews, there is no objection of such review being made by the competent authority. Such authority shall competent to increase or decrease the rate of subsistence allowance up to 50% of the amount of subsistence allowed initially granted according to the circumstances of the case.
So this discretion is after 6 months.
6 months. After 6 months.
Then appears he is correct.
Well, I'm just look me through, my lord.
Yes, have it. We are looking at it. You want the book?
%50 of the amount of subsistence. 75. 57.
And what are the person concerned? He was holding the additional charge of the Inspector General of Police.
3 months under suspension.
Additional charge. If somebody holds the Inspector General of Police, then according to the notification, he is competent.
He is the cadre controlling authority.
Cadre controlling authority.
So after 6 months, it says 50% of suspension allowance, subsistence allowance can be enhanced. That means 75%.
75%.
The lordship can takes up, my lord, B, the later part, retrospective effect. Now, if I'm
Whatever it is, but after 6 months.
After 6 months.
Retrospective, prospective is immaterial. After 6 months.
My lord, it says 3 months. You will also kindly look at subject to
Yes.
consideration.
59
First review, read the first review first.
Yes, my lord. First review, my lord, says a review of subsistence allowance shall be made before the end of 3 months from the date of suspension.
3 months.
3 months from the date of suspension.
Correct.
This will also give an
So
opportunity.
this gives them an opportunity to review the subsistence allowance. This is an absolute discretion.
Absolutely, my lord.
Then comes B.
B. The second and subsequent review, my lord, there is no objection to such review being made with authority. Such authority shall be competent to increase or decrease the rate of subsistence allowance up to 50% of the amount of the subsistence allowances initially granted according to the circumstances of each case. A second or subsequent review can be made
At any time.
at the discretion of the competent
At
authority.
any time, it is open-ended.
Yes, my lord. Now the authorities have, my lord, before this order passed by learned tribunal, well, in the earlier round of litigation, before the authorities took up the minutes of the meeting, before that the subsistence allowance was already increased. If your lordship takes up page 67, your lordship will find there is a clear-cut indication to that effect. Page 67 is the minutes of the meeting, well, which has been handed over to me.
No, so what is the illegality?
Well, illegality is, I may say,
After 3 months, they conduct a review. There is absolute discretion that they can review the subsistence allowance. The second review, they say, the rule says at any time. After 3 months, it can be done. When they exercise this review, they have a discretion to increase the subsistence allowance up to 50% of the subsistence allowance, meaning thereby 25%. So 75% is the maximum that you can get, which you are getting.
yes, my lord. The only thing, my lord, subject lordship kindly leave, my lord, what has happened, my lord, without reviewing the substantive question of suspension in the earlier occasion, my lord, they have only enhanced the subsistence allowance without going into the review of the substantive question of suspension. Now, my lord, if your lordship takes up page
So where is the requirement that both things have to be reviewed?
my lord,
Let us see.
first review says, my lord, not only the substantive question of subsistence allowance, the substantive question has to be reviewed. My lord,
But
that was
also the substantive question of suspension.
My lord, so first review within 3 months, my lord, what they are required to do, my lord, is not only
Both.
enhancing or decreasing the subsistence allowance, but also the substantive question of suspension is required to be reviewed.
Yes.
So, my lord, that they have done, my lord, I may say they have voluntarily done only with regard to the my lord, the
Where is the order?
my lord, your lordship can take up page 67. That is what I am saying, my lord. That will be made things clear.
67.
67. My lord, this is the minutes of the meeting which was handed over to me by my lord, the Superintendent of Police Bankura, that is page 66 via communication. Now, my lord, if your lordship takes up, my lord, discussion part, my lord, just I'm saying, my lord, why this order, I may say, it's not in conformity with the rules or the memorandum. Copy of the status report of Sri Kumar Gautam IPS, the inquiry officer of Bankura district proceeding number such and such, drawn up against such and such, formerly Inspector Police of DIB Bankura was placed before the committee. The suspension order issued on 15/7/2024, and accordingly the subsistence allowance of 50% of the pay of amount was allowed. In terms of memo number 376 dated 2012-2024, the subsistence allowance of Sri Hajra has already increased from 50 to 75% and other admissible allowances proportionately. But it never speaks of any review taking place within 3 months, as mandated in the rules itself.
That was not done. That is why you approached the tribunal.
The
Tribunal said that you take a decision. Now they have taken a decision.
Now what they have taken, my lord, the rule says, the memorandum says that it has to be constituted by the, my lord, either the principal secretary,
Right,
secretary, or
that
the
you have said that he is saying that he is now the cadre controlling authority, therefore he is competent. The tribunal has also taken note of this fact that now because he is officiating as the IGP, therefore he is a cadre controlling authority.
The cadre controlling authority is, my lord, appointed of the IGP is the Director General and Inspector General of Police.
Maybe, but the rule, the memorandum says cadre controlling authority.
It's not the cadre controlling authority of the West Bengal Police, my lord, subject to kind constitution.
You have to show us that IGP is not competent. You have not shown us anything. Merely for your saying it cannot be accepted. They are saying that he is officiating as IGP and now he is competent as a cadre controlling authority. This stand has been accepted by the tribunal. You say it is wrong. Why it is wrong? You have to show.
But then lordship grants me sometime, my lord, I will file a supplementary.
But this is the only issue.
Now, my lord, if your lordship says, my lord, and the other issue is, my lord,
No, even if we don't say, you have to say this is your case that he is not competent. And you know the tribunal has held him competent because of this reason.
Only
you are required to tell us that no, this reason is wrong for this reason. But you are not here with any such proof. Now, insofar as continuance is concerned, the order says shall remain in effect until conclusion of the departmental proceeding or otherwise directed.
The decision part, your lordship, yes, otherwise direct, the very first point.
So they will take a decision after some time again.
After 180 days.
My lord,
180 days.
kindly, my lord, if your lordship
The
allows.
next review is after 180.
180 days.
Which provision?
That is also on the memorandum.
Decision ground number 3. The matter will be reviewed only after 180 days if necessary. Two conditions.
Where is that?
The last 3, page 67.
My lord, the memorandum says,
No,
memorandum.
no, where is the provision in the rule that after 180 days it has to be reviewed?
Can you see the rule 71?
71.
Yeah.
No, is there any provision in the rule that proceeding is preferably should be concluded within such and such time?
No.
A departmental proceeding?
Although, my lord, your lordship, those judgments are there, my lord, of Premnath Bali versus Delhi Registrar Delhi High Court.
No, we are asking in the rule, is there any such provision?
No, but no time limit has been meant, but suspension order has to be reviewed.
But then if you continue with a suspension like this, that itself will become punitive, even if no punishment is awarded. How
No,
can you?
but can you see, we have decided to 180 days or till continuation of the distribution. If ultimately.
Where is that? We don't find it.
The suspended officer will continue to receive subscription of 75% basic pay along with the the order of suspension remain till effect until conclusion of the deferred proceedings or until further otherwise directed.
Where do you get 180 days? That is what we are asking you. Because if it is 180 days, then now it is already due.
No, I do not know what are the stage of it.
We know because he was suspended in October.
No, this order was March 2025.
No, 180 days from the review or 180 days from the suspension?
No, from the date of review.
No, it can't be.
The matter shall be reviewed only after 180 days if necessary.
So 180 days is over.
No.
What do you mean if necessary?
180 days from March 2025. March, April, May, June. 90 days, only about 90 days. Another 90 days is there.
My lord, may I, if your lordship takes up the, my lord, the. Yes. My lord, if your lordship takes up the memorandum once, my lord, your lordship query of 180 days will be clear. If your lordship takes up the memorandum, my lord, page 60. My lord, I should be candid, my lord, with your lordship. My lord, 3A II. My lord, at the middle portion, functions. My lord, in every case, the review shall be done within 90 days from the date of order of suspension or deemed to have been placed under suspension. In case where the period of suspension has been found to be prolonged, the next review shall be done within 180 days
So
from
then
the
there
date
is
of the last.
substantial compliance with this. There is a substantial compliance with this. Because 90 days, within 90 days, they have done this. And they have said that within 180 days, we'll do it. So 180 days will lapse in a couple of months, in August.
My lord, my suspension is of 15/7. Even if I assume by that exact numbers, my lord, 15/7 is the date. So 3 months is, my lord, 15/10. And my lord, from 15/10 to 180 days, if I even assume 6 months, it is 15/4.
No, where do you get the 7 date of?
That is the date of suspension.
No.
15 July 2024, initial suspension order.
That is what I'm saying. Date
But
of
you gave us a date, 15/7/24.
Yes, sir. 15/7/2024 is the date of suspension, my lord. Then, my lord, 90 days would be 15/10.
In October, it was due, first review.
Yes, my lord. The next would be, my
They
lord,
didn't do it. You came to the tribunal. They finally did a review when?
my lord, they had done March, 13th of March. And my lord, if I go by even that part, my lord,
17th of March.
is due.
17th of March.
Then the first review milestone has already been crossed. What can be done now? This memorandum of 16/11/2012 is not in dispute.
No.
Then your exercise undertaken during the review, is it sustainable as per this memorandum?
Your lordship, who has been informed?
That issue you have already said. We are saying the procedure which you have adopted for review, can it withstand the test of this memorandum? Look at capital B on page 2. B1.
B1. The review committee, sorry, B1. Review committee was assessing the justification for further continuation of the suspension shall look into the progress of the inquiry investigation against the officer.
Where is all this? What is the, where is the consideration? What has happened in the inquiry? Come to page 67. If necessary, we will review after 180 days as if they have been given all the discretion in the world to do whatever they want. They have uncanalized power. This does not withstand the test of the memorandum.
Then I shall have to take instructions on this point, madam.
What
is the-
instruction there?
No, but whether this 2012 notification has been subsequently amended or not, nothing.
No, but this was before the tribunal.
No, under 2012 notification, we are in 2025.
Did you file a reply before the tribunal?
I do not
No, my
find
lord,
it.
no reply, no rejoinder, nothing. On the very first day, my lord, the tribunal, the state said, my lord, the ADG is a
All right, then we'll ask you to find out whether it is invoked till date.
No, I'm not sure about because by order number 1, it has been disposed of without calling for appeal.
So we are asking you to find out whether this memorandum is invoked.
Yes, sir.
You find out, you let us know.
All right. Give me short direction for affidavit.
Yes, we'll do that. Yes, please take it off.
Item number 9.
Yes,
Appear on behalf of the petitioner.
yes.
I was initially engaged as a sweeper, casual worker.
When?
This was done sometimes in 1999.
99.
I was getting at that time a remuneration of rupees 300 per month.
Yes.
Then Miller, the remuneration was subsequently increased to rupees 700 per month. And now Miller, at present I find that a bill has been given at page Miller, this is page Miller 44. And from your lordship will be pleased to find that at present I am getting an amount of rupees 7905. 7905 at page 44.
There appears to be some. The last page in our brief is page 40. Annexure P by 15.
কি করেছিস রে? এই annexe বলছে যে জজ সাহেবের
Are we looking at the same brief?
this is
96 of 25.
WPST কত নাম্বার আছে?
WPST ঠিক আছে WPST 75 WPST 96
Yes, we have that brief.
96 of 2020
The last page is page 40, page P5, annexure P15.
Bengali document.
Huh?
Bengali document.
No, there are
Yes, February document.
Then the
order of the tribunal. The last page is the order of the
Oh,
tribunal.
the tribunal's order has also been numbered.
No, not numbered.
Oh.
This has not been numbered because there is a system in our code.
No, it should not be. Then how do you get 44? That is what we are.
and the date of order 12 April 2023. Application filed in 2025 after 2 years.
Page 38 too.
12th April 2023, order was passed by the tribunal, and application filed in 2025.
Page 38.
Writ petition filed in 25.
25 after 2 years.
It is hit by limitation.
25.
It is hit by limitation.
Well, limitation act does not apply, but within the reasonable time.
But may I just, I do not know.
38. Can you give us the detail of the document? Then we'll find.
38 page
38.
38
38 we have.
P14 is 38 P14
Annexure P14.
P14
Yes, page 38. 7905. Got it. Yes.
This is kindly say this is bill number and date. The date is 4th of February 2025, and I am Pradeep Nayak. I am getting 790.
39 yes page 39
Miller, I just want to indicate to my lords Miller that so far as my matter is concerned, I'd say Miller, with the deepest of respect,
You want permanent absorption?
yes, Miller, I say Miller, I know that the law in the subject after Uma Devi, in Uma Devi Miller, there is a paragraph, Miller, I say Miller, today I am really Miller, I am being placed to a very discomfortable situation because why I say in Uma Devi there is one exception clause.
Yes. Forget about paragraph number. That I also don't remember.
Paragraph 53.
But huh?
Paragraph 53.
See.
As a one-time.
Yes, 10 years competent authority after due process and all.
3 judgments thereafter, which had Miller.
And against the sanction post.
Sanction.
So
Now-
these 4 requirements you will never fulfill. All these engagements are not against the casual sanction.
I want to show to my lords, that kindly see the staff position, that is the sanction strength, that is at page 31.
Must be, maybe, but merely because vacancies are available, that will not vest a right in you.
No, not at all. I do not say that.
Unless the initial engagement is against a sanction posed by the competent authority after a due advertisement continuing for 10 years without order of the court. These 4 parameters have to be fulfilled before.
That's right. Now, Millard, your lordship may kindly consider. First of all, Millard, I was initially engaged. I should not say appointed.
Correct, engaged, yes.
In 1999. Then, Millard, I would be showing to my lords, Millard, few Millard documents where, Millard, your lordship will be pleased to find that, Millard, at page 17. Millard,
17.
Page 17. This is nothing but punishing report against engagement of casual employee. This was issued by the subdivisional refugee relief and rehabilitation officer in charge to the subdivisional officer, wherefrom it appears, Millard, that I was working. Then I find, Millard, I should say to my lords that again in 1999, Millard, there was, Millard, a particular letter addressed to the collector, Millard, indicating that this person is working. And the most important letter which I should show, Millard, your lordship may kindly take the pains, Millard, to come to page 20. Millard, this is one document, Millard, which, because I say, Millard, I have no strictly enforceable rights. But, Millard, I only, Millard, pray for my lord's kind consideration of a right of consideration. Kindly see, Millard, page 20, the second paragraph. In the first paragraph, Millard, I say, Millard, I would like to inform you that at present 2 permanent staff, that is.
So Darwan is not available. That is the first paragraph. The Darwan is not available. Yes.
Considering the above urgency, one Darwan may be allowed to engage at Ranaghat Women's Home on daily wage basis and also as a temporary measure as early as possible. In this connection, as per suggestion of the acting SDRRO Ranaghat and the Superintendent Ranaghat Women's Home, Sri Pradeep Nayak, that is my client, may be entrusted with the job of Darwan as well as bill submission and carrying official file from Ranaghat Treasury and SDO Office Ranaghat as purely temporary and daily rate basis until posting of a permanent Darwan. Then, Millard, your lordship may kindly consider that, Millard, I have annexed, Millard, at page 21 a circular, Millard, which is issued by the Government of West Bengal Finance Department, wherein, Millard, there is an indication that how much I am entitled to as a wage or Millard, as a remuneration. Then, Millard, it appears, Millard, that more than 10 years, if it is done, then 11,000. Now,
That is group C.
Yes.
You are in D.
I am in group D.
So group D is 8,500.
I stand wrong, Millard. I stand wrong. Now, Millard, kindly see one document at page 24. The letter of 2015 from subdivisional officer again to the Deputy Refugee Relief Commissioner. Millard, I skip over the first because it contains the same thing. Considering the above urgency, at least one staff, Darwan or guard, may be posted at Ranaghat Women's Home as early as possible as an alternative measure and until posting of above staff, temporary arrangement of engaging a local person, namely Sri Pradeep Nayak, who is at present working at Refugee Relief Office as a part-time worker since May 1999 as a Darwan guard time for full-time may be permitted as on purely temporary basis in terms of GO number 3727-8 dated 28th of May 2009. With a record GO number. This is GO number. That I am handing over to
2009 GO.
Yes. না 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 এটা তো এইখানে আপনার কাছে অনেক অনেক বেটার আছে ওটা কেন এসব বিয়ে করছেন ওর কাছে অনেক ভালো। এটা দিয়ে
একটা এক্সট্রা দিয়ে দিয়েছি
Yes.
Amila, dear Lordship, may kindly take consider that while this was the situation which was subsisting in the case, it appeared to us, the office, also there was a particular note sheet given. That is in the next page at page 24.
Page?
Page 24.
within bracket A.
A, 24A. 24A.
This will not,
Court sheet is
this will not,
I do not. I just only, your Lordship may kindly consider that my lords have laid down the law that normally a document which is belonging to the official office that should not be taken note of. However, for the purpose of adjudication of the matter, if something comes out from the document, that the court can take note of. I do not say I am
is file notings.
say that it will not
This will neither create a right in your favor nor it will take away any right.
in a better position.
Yes,
It do not place me in a better
in a better position.
I do not know how the note sheet goes to an employee.
That you are responsible. Ask your officer how they have done it. He can say the crow dropped this paper in his lap.
I, Millard, your Lordship, may kindly recall that while I was a very raw junior. Then Millard, I was the chamber junior of Mr. Ashok Dey, senior advocate of this court. One day, one particular question came up for consideration that a very privileged document I placed before the court. I was a very raw junior, I did not know the law then. Then Millard, the court asked me, how you got this document? Because this is a privileged document. Then I said, I made a submission that my lord kindly permit me to come tomorrow. Then I immediately rushed up to my senior. Then a senior told me that come to the chamber in the evening, I will show you the law. Then Millard, he referred to an All England Law Reports judgment that was ultimately the principles laid down in the All England Law Reports judgment that was taken by the Supreme Court for the first time, and there the Supreme Court is saying that if a document is very privileged, the court cannot question the source from which you have obtained the document. The court is only concerned as to whether this document is necessary for the purpose of adjudication of the matter in issue. That is the first thing which I came to learn. And then, beloved, on the next day, when I showed the judgment, the judge appreciated me. Of course. That's the reason I also told your lordship that these note sheet do not place me in a better position.
It is only a note sheet in the process of the office. Unless it culminates into issuance of an order, no rights can be claimed on the basis of this document.
I am not being placed in a better position.
No better position.
Now, Millard, only thing I say, Millard, that kindly see.
But why you have referred to this, we are unable to appreciate. Therefore, we are asking you. 20th May 2009.
Since this was referred to in the letter of page 24.
Your order.
No, but you referred to one other document at page, the one where you are supposed to get 8,500 per month.
Yes.
Page 21.
1 second. Yes.
So instead of this 2009, this is, are you getting this 8,500 per month?
No. more than 10 years, 8,500. I'm showing to my lords Miller, your lordship may kindly.
7905.
790. And they are the for equal part. Because I say at the very threshold, I say I have no right. They may not.
No, but there are few other memorandums we have seen in the course of some other matters
Yes.
where people have continued. There is some security of tenure provided that they are to be continued till the age of superannuation.
That is only the thing I.
Where is that memorandum, that GO? We have seen it in so many cases.
It's September 2011.
Correct.
Kindly see.
Absorption, right now it is like crying for the moon. So therefore,
I also do not.
yes.
No, Madam, kindly see page 21,
Page
20th May 2013, first memo, 16th September 2011.
16, yes, it is noted there.
This is the parent memo,
Correct.
2010 original memo, there's
Correct.
amended in 2010, cross 10, is that there must be a sanction force. Then
So there are three. There are three in that series. Three memorandums. Three GOs.
2010, 2011, 2016.
16.
Now I say Miller, I very respectfully submit.
On that basis, you have not seen those.
We have not. But I can.
Yeah, going to continue.
Okay, এটুকু help করো, তারপর আর আমার কিছু help করো।
Outside.
May I say one thing?
Now, my husband has not answered the questions. Order passed into.
There is at least this much is clear from your official documents that from 1999 he has been working. And today for the last 10 years, from 2015 as a Darwan.
But as a part-time.
Correct. So therefore that security of tenure, which you have already decided to give to such employees, you should give him, but he is sanction post.
Sanction post is not.
That we will consider. Let him come with that, then we will consider. Whether sanction post is required or not, in every case you raise the same issue. It's already decided. There is a judgment, you cannot insist on a sanction post because such vacancies, such engagements are never done against a sanction post.
And this will never be done.
There is a judgment we have already considered in that.
The lordship has delivered that judgment.
Next week that.
সেটা আমার কোনো অসুবিধা নেই। Next week.
15 July 2020.
15 July.
July 2019. The last
2019.
2010, 2011, 2016, 2019. 4 circulars. 4 circulars.
15/7.
2019. April 2010 and September 2011.
Anytime, Miller, in the
Next
next week, we should find it. I cannot say anything. I cannot say anything.
After some argument,
My lord. 18.
Yes, he Miller has some personal. I have nothing to say. I am every day in the court. I have no other place. Appearance will be the appearance will be the.
Item number 10.
Number 10 on behalf of the petitioner, my lord. My lord, this matter is filed and thereafter it is fixed on 16/6, my lord, Monday. Somehow it will be listed by.
Writ has been filed by,
Filed by
then
me,
you
my lord.
proceed.
No, my lord, it will be listed on 16/6, my lord. That's why service is not completed.
You proceed with the merits.
But I am not carrying the brief, my lord.
Then tomorrow you come. Forget about 16th. Not today. If there is merit, we'll direct you to serve notice. If there is no merit, we will consider. You argue your case.
Sir, kindly fix it 16, my lord.
No, sir, come tomorrow. Come tomorrow. What is the magic in that date fixed by the office?
Not, my lord,
If it was a,
senior
if it,
officer,
if,
senior, my lord, that's why, my lord.
all right, list on 16th.
My lord, in this matter, I am appearing on behalf of the petitioner. My lord, two restoration application has been filed. My lord, one problem is this. My lord, the learned advocate appearing for the state respondent, my lord, he has expired. My lord, Joyatosh Mojumdar. My lord, his junior, my lord, yesterday I asked him to receive the copy, but he said that
How he can when the senior is not there?
my lord, he is not in the panel. My lord, so I beseech your lordship, my lord, kindly,
There is a state council here.
my lord, I will give here and now. Here and now.
His restoration has to be moved. The learned advocate who was appearing for the state, he says he is now no more.
Last ex-DPO. What is the copy start to the learned DPO?
Yes. Well, I will serve to this. Government.
The GP.
Yes, ma'am. Well, kindly give a order, my lord.
It is submitted. What's his name? One minute.
12.
I'm sure was there. Mr. Mukherjee was there. I went immediately at 4:30. Right now. Yeah. At 5.
Have served the copy of the petition upon all the respondents. In terms of the last order dated 23rd May 2005, the restoration application.
Restoration. Can one?
Yes. This is for default, my lord. Page.
How many private respondents? One only.
One.
So let us see the merits. Restoration, what is there in restoration? Tell us. Tell us. Can you proceed today? Can you proceed today?
Tomorrow, yes, if your lordship only guns, tomorrow.
You are here tomorrow.
Yes. Tomorrow.
Not today. We'll take up the entire thing unnecessarily.
My client is right now 85 years of age. And she's
ठीक
not
है,
getting-
All the more better, it will be decided immediately. Yes. Not today.
That was dismissed back in 2019.
Huh?
Dismissed back in 2019. Are you placing tomorrow?
All right, we'll see.
Application is restored.
No, tomorrow. Tomorrow, entire thing will consider.
13.
Contempt petition, why are facing the contempt? That's why not matter.
Today,
My lord.
today there is a contempt.
Contempt. That cat, I have to reach to
Today is already over.
cat. No, cat matter is spent. One is going on, my lord, my item 46, there I have to rush to cat.
In this matter,
Yes.
contempt arising out of this case.
Only restored, then, my lord, tomorrow I will matter. Only restored, then I can say. that.
Tomorrow we'll take it up. You talk to the council who is appearing there.
It might not expected that the contempt is on a tomorrow.
Tomorrow.
I have got the order.
I'll instruct him so that he doesn't.
No, today. Order cards. I have got the order.
Then take down an order.
I'll instruct-
No, it is on 10/6.
Your lordship can receive this order.
No, this is the order.
Oh, yes. No, last order, your lordship can the order of the tribunal. একটা কপি দেখ।
This is of 22/4/25.
Yes, then, my lord.
Then on 20th May, it has been taken up. It is only directed that it has to be listed before the division bench.
Well, my lord, the matter order be passed in the chamber, but
Anyway, we'll see.
yes,
Get this order signed during recess.
ঠিক আছে, নামগুলো দিন।
Great.
আমি যাবো ওখানে কন্ট্যাক্ট করে।
Chal raha hai, respond.
Item 13.
My lord, in this appeal, my lord, I have challenged the order dated 13/11/2024. My lord, my humble submission with regard to pay, the order is contradictory with page number 184 of my application. Whether this kind of order can be passed by the writ court or not, my humble submission is this. The coordinate bench of this honorable court has already passed an order in the year 2014 that these are the subjects of civil court, not before the writ court, because many factual aspects are there. So, my lord, kindly sees the observations and the factual metrics involved. My lord, what has happened? I have filed a patent infringement suit before the learned civil court, and my lord, in that
Come to paragraph 18 of the order.
my lord, sufficiently insulated.
Then
Sufficiently insulated.
What is
My lord, it is sufficiently insulated.
although earlier the honorable judge has said that it is a different that decision, but everything
court
has
has
been
not
left,
decided. Court has not decided anything, and it has left upon the
and it is being done in so many cases.
my lord. My lord, the thing is that I am on different score, my lord. My lord, what has happened? I have filed a patent infringement suit.
That is not the matter here.
My lord.
You are appearing as a respondent only because you say there is an injunction that should not be violated.
My
The court has taken enough precaution in paragraph 18. Nothing.
It is covered, entirely covered. I am aggrieved with even if so, my lord. My lord, the factual matrix which has been recorded at paragraph 12 is factually
Irrelevant because in 18 everything has been left open.
left over.
So therefore they will consider if it is other than a fuel cell battery, they will give. If not,
My lord, one more
has it been complied by now?
My lord, it has been
Who is
complied. My lord, one thing, my lord.
Who is for the writ petitioner?
My
You are
lord,
for the state. Oh, you are for the writ petitioner. Registration already done.
my lord, one more thing, my lord. My lord, kindly takes your lordship to page number 113. 113 of my application. No, that is not a battery, my lord. This is factually incorrect.
We are not, neither the single judge has gone into it, nor there is any scope for us to go into this.
My lord.
The issue is whether the order is sustainable or not. You say there is an infringement of some patent that you have. That has been safeguarded.
My lord, that has been safeguarded, but order is not tenable under section 223 of the Motor Vehicle Act.
Yes.
Section 223 of the Motor Vehicle Act says that registering authorities, MLOs, Motor Licensing Authority, Regional Transport Authority doesn't have those powers to sweep in these things, to enter into these things, my lords. This is a specific statutory provision passed by the legislature. So, my lord,
See,
I am on
whether we are to take up an issue academically,
my lord,
your only objection is that your order of injunction should not be breached.
my lord,
That the court has taken.
my lord, I don't have any patent over the battery. That is factually incorrect.
We don't
My
know.
lord, my humble submission is that.
But that is your submission recorded in the order.
My lord, it was
That
not
is
recorded.
your submission recorded in the Honorable
My
Single
lord, it was
Judges.
not recorded. That is the thing.
Then you should have filed a review.
My lord, kindly cease.
We will not allow you to enlarge the scope to whatever you want to say. It is not an open forum that you can say whatever you want.
No, my lord. I'm
Your
not
specific stand has been recorded by the Honorable Single Judge, which you have never opposed.
My lord, I'm not opposing.
So
with regard to
therefore,
paragraph 18.
no, earlier paragraph, your stand has been recorded.
My lord, earlier.
What is your objection has been
My lord,
recorded.
I will come to that. With regard to the earlier paragraph, means the first judgment is passed with regard to Mahindra and Mahindra.
Not required. We are not going to go into the first judgment.
My lord,
We will not travel beyond the single judge order.
My lord, I'm not traveling.
Not
my lord.
1 inch.
My lord, in the impugned order itself, there was a reference given by the learned single judge with regard to WPA number 2070. My lord, in paragraph
Mr. Counsel, you were represented by an advocate.
My lord.
He has made submissions recorded
behalf.
in paragraph 9 and 10 of the Honorable Single Judge's order. Now you cannot travel beyond that.
My lord, I am not traveling, my lord.
Read what you have said in paragraph 9 and 10.
My lord. The patent holder is being represented by Mr. Mukherjee, my lord. My lord, I agree.
10.
My lord. Mr. Mukherjee submits referring to the decision passed on April 21, 2017 in 11061, that court directed therein for necessity for being satisfied about the difference of the vehicle with respect to the technical use for running.
Now next paragraph.
My lord, he has relied on the said order of the board.
You have relied on that. You have relied.
My lord, it was wrongly recorded because order says different.
This is not the forum.
My lord,
this is not the forum.
My lord, I most humbly agree. with this.
Therefore, we will not entertain such plea. We will not even consider it.
My lord, I am not on that. I'm on different score, my lord.
We are not going to go on any different score.
My lord,
you have taken a stand before the single judge. Relying on that stand, the single judge has passed certain directions. Therefore,
My lord,
there is no scope for any.
I am making myself clear at the bar that I am not disputing with regard to my earlier consent,
Yes.
which has been given before the learned
And
single
what
judge.
remains?
And that has.
Why should we go into academic issues?
I am not praying for interfering with regard to the parent portion of the order.
No, anything.
My lord, I am not
anything.
My lord, I am only on paragraph 13. My lord, kindly sees the paragraph 13 of the impugned order. For once, my lord. My lord, by dint of the order by this court dated February 16, 2022.
How is that relevant? How is that relevant?
My lord, in this
whatever is being done under paragraph 18. All this is irrelevant.
My lord,
the court has
I
not said.
agree with this.
Therefore, there is nothing.
Something, my lord.
Sorry.
Something with regard to paragraph 13, I have to submit, my lord, before your lordships, my lord. My lord, by dint of the order by this court on dated February 16 in WPA number, the court directed Transport Directorate, Government of West Bengal for granting registration to e-vehicle manufactured by the petitioner therein, subject to the said vehicle or batteries, my lord, herein. Subject to the said vehicles, batteries being different and distinct from the category forming subject matter of the suit before the court. That was the mother case, first case which was relied upon.
We are not going to go into that case. We are not. If there are errors of record, the remedy was different. This is all order passed in your presence, recording your submission. From para 9, 10, 11, 12, 13, it is all in your presence. If you wanted, you could have gone for a review that expunged this. This is not a correct record. It is an error of record, it is a mistake of record. This is not the forum.
Then, my lord, I will go for a review.
You do whatever you want.
My lord, I pray for withdrawal with the liberty to seek review.
All right, as prayed by learned counsel for the appellant.
I'm grateful to your lordship. Yesterday, your lordship had that matter. Only one point troubling your lordship, that during the pendency of that petition, if any order passed by the authority, I have to go before the tribunal in terms of the 2010 volume 4 SCC 554.
554.
Now, this point is not res integra by this honorable bench itself. Also, your lordship entertained the writ petition, the interim order passed, taking plea of that Mr. Mukherjee appeared in that matter. That plea was also taken, and that was turned down. Interim order passed, and your lordship's court made it absolute by way of mandatory order. So, my lord, after thorough searching, my lord, I got here similar situation. Initially, order was passed by the tribunal. Authority considered, referred the matter before the superior authority, but finance department. The authority did not take any step. Or I made a second attempt.
So that was the doctor's matter.
Yes. Now, yes, my lord, I have bought that. Yesterday, my lord, your lordship court held this. That in the meantime, if any order passed, that cannot be a new cause of action. Your lordship entertained the matter, and my lord, the transfer of doctor, yes, to AIMS. Your lordship.
In that case, there was a necessity of challenging the tribunal's order also.
Yes.
Because the tribunal had already decided against the petitioner.
No.
Therefore, the tribunal's order could only have been challenged before the High Court. Therefore, we said that the subsequent order will not come in the way.
That not. It is another matter. I am placing this. Here also, there was a direction by the tribunal to consider. Irrespective of that, tribunal could have decided the matter on merit. Tribunal said it is the authority to decide. That order has been challenged before the honorable bench.
Where is that?
Yes, I am giving. So, honorable, during the pendency of the writ petition, the authority, considering the order of the tribunal, rejected the prayer.
No, if we remember correctly,
Yes,
the,
yes, my lord. Dear lordship, I
the
am giving.
tribunal had accepted the stand of the state that there is
Here also,
deficiency of doctors. After accepting that, it said you consider. Therefore, we
here
said
also, the I
here
shall show
the what the tribunal has said. Let us see.
Yes, no, let the judgment be placed first. Your lordship is correct.
Let's see the
judgment. Yes. Now, in my case, here the authority themselves.
No, what is the tribunal's order? Is it already deciding the issue, or it is
No,
leaving everything?
initially it was decided in terms of the judgment of the honorable court, page 81. And considering that, they have considered for giving me relaxation. First order of the tribunal, kindly come. Order dated 3/8/2022.
No, 12/8/24.
Yes, no, 3/8/22, page 81.
3/8 or 12/8?
No, I believe it is a 3/8, page 81 of the petition itself.
Oh, this is earlier order.
Earlier order.
No, that is not the point. Point
Yes.
is
Now, in terms of this, the authority considered at page 83, 84.
it is this order which they have complied.
They have complied
this order.
This order.
Let us see then. Yes.
Yes. And proposal has been made. Let us go through 83.
But this order was not challenged by you.
No, because it is my favor. Thereafter no step was taken, and if Lordship kindly sees the authority who passed the rejection order now, that particular authority also, page 71 and 72, kindly sees. Page 71 and 72.
But then this is factually different from the judgment that you are relying.
But, ratio. I am on ratio.
No, see the ratio.
Ratio.
Please
Kindly
see.
see.
We have passed that order based on a judgment of the apex court that without challenging the basic order, subsequent order cannot be.
That plea has been taken in that matter also.
Yes.
So kindly see. But I have gone through twice.
That plea has been taken, but it has been overcome because tribunal's order was necessarily to be challenged, and it could only be challenged before this court.
That has not been challenged. Tribunal's order.
Yes.
There are also direction for. Let me read. Then the Lordship will. I shall clarify. But, internal page 3. There was a direction by the tribunal for consideration. I am reading for entry.
Which one you are reading?
Order dated 15 January 2024. The plea which is being taken, citing that judgment has been also quoted there. May I read for your Lordship? Mr. I, learned advocate appearing for the petitioner, submits that the petitioner approached the tribunal praying for mandatory direction upon the respondent to accept the petitioner resignation and to issue the release order in favor to enable him to join the post of assistant professor department such and such AIMCS. Kolani. The learned tribunal, without adjudicating the matter, relegates the matter consideration for respondent number 2. In my case also, I paid for consideration, not consideration for mandatory order in terms of the earlier order of the judgment. Now, he further submits that the libel tribunal cannot delegate the power to decide any dispute which is required to be decided exclusively. In support of such argument, reliance has been placed upon judgment such and such. Now, he submits that the identical fact situation coordinate bench of this pass the interim order upon concerned authority to issue provisional certificate in favor of the petitioner. Let the order be produced and kept on record. Now, submission of Mr. Mukherjee is there. Mr. Mukherjee, learned additional government pleader, appearing and submits that in terms of the order passed by the tribunal, in my case also, tribunal, a final decision has been taken by the principal secretary. As such, a fresh cause of action has arisen, rendering the present disposition infructuous. In support of such submission, reliance has been placed upon the judgment delivered by such and such. Now the judgment was quoted. In reply, Mr. Roy
This is an interim order. How it can be a binding precedent?
That has been made absolute by subsequent order. I have annexed all. In terms of the another honorable coordinate division bench,
yes,
this order made absolute.
Where is that?
Yes, I have annexed all these judgment of your lordship's bench.
WPST 204 has been made absolute by which order?
Yes, by 13 March 2025. Another order has been passed releasing the no objection has been given.
But that was a matter of grave urgency. He was missing the date.
Subject to correction.
In every case, we cannot go and do this. That in
urgency is therefore there is no absolute but to go and again.
If there was, you think we would have passed the earlier order? We have already passed.
And kindly come to page 71 and 72. That particular authority, in my case, directed my employer to calculate and give the fresh proposal.
Right now, we are only whether the order is to be challenged or not. Without challenging the order, can you get a relief?
No, your lordship, kindly come the nature of the order itself. I have annexed by way of can. Whether this can be said to be an order of the authority. Any order that
point is whether we can look into it directly or it has to be taken before the tribunal. That is the only issue.
That's the issue. I know that your lordship are thinking about, but in respect of matter regarding pension, your lordship can mold the relief for ends of justice, because in those cases I have checked it up. 24 judgments has been passed relying 2010-4. In most of the matters, including our judgment honorable division bench, that is stand on L, in most of the cases, the persons were not the party before the tribunal. In those cases, remitted them to honorary. In other high courts also, in those cases, the approach directly or by way of can. Here, my case is to some extent different. I have availed. I have got some order, but that was not the mandatory order. I have come before your lordship. In the meantime, they have communicated contradiction. In initial stand, they said that yes, you give the proposal so that we can consider page 71 and 72 in respect of the DCRB rules.
71.
1 and 72. That particular authority who passed the impugned order, passed the same order.
No, let us see the can first. Where is what is the order that has been passed?
Yes, page 11. Just a communication to my employer without citing any one of the sections or just 5 lines order, keep order. Which provision I do not entitle, nothing has been given. Only sort of communication. Page 11 of the can.
He was the person who was directed by the tribunal. This is the authority who was directed by the tribunal to pass the order.
Yes.
Secretary.
Yes. Yes. Yes, proposal has been sent by the secretary, and in terms of the tribunal order, same authority, my lord, page 71 and 72. Kindly come again. From the deputy secretary to the IGR. Proposal has been given. Since no step was taken, first tribunal application. Directed for consideration, they have made the proposal page 80 to 83. And now, no step was taken, second time tribunal application for consideration. Instead of mandatory direction.
Without challenging this order, can you get a relief?
With great respect, I can. Because in respect of consideration order, I can. There is a judgment of honorable division bench. I have annexed this. There is a direction for consideration. I have challenged. Justice Kapopati Chakraborty division bench, he appeared, took that plea. Because since there was a direction for consideration, I am not the aggrieved person to that sense. My honorable court directed. No, it should have been given the mandatory direction for giving the pensionary benefit in terms of 2010 volume 11 SCC 694, because it is the duty of the tribunal to adjudicate the issue regarding pensionary benefit. And that your lordship also in that judgment 204 considered that judgment. I have page to paragraph 20. So it is the fundamental right to get pension, not for consideration. 2010 volume 11 SCC 694. In that judgment of Mohan Kumar also, that judgment has been considered. In the compilation 10-11 SCC, State of West Bengal by Subhash Kumar Chatterjee. দশের 11 বার কত 10 এর মধ্যে নেই, আলাদা আছে দেখ। এটা স্টেট অফ ওয়েস্ট বেঙ্গল। এলি না? আর পারবো না, আর পারবো না। 10-11 SCC I have only one copy. Kindly take paragraph 20 of that judgment. It is the duty of the tribunal to decide the case on merit for mandamus or
You never challenge that order. You were seeking enforcement and compliance of that order.
yes.
So now how can you make this submission that it has not performed its
That is why
duty?
I am before your lordship.
But you have not challenged the order.
I have challenged last order for consideration.
The order passed by the tribunal
Yes.
directing them to consider.
That has been considered at page 20, 82 and 83 in terms of that earlier order. I am not saying so. I am saying in respect of the impugned order before your lordship, I am for fresh consideration. I can do this for seeking mandamus.
Again, they have directed for fresh
Fresh
consideration.
consideration.
But now it is infructuous because there is already a consideration.
There is a consideration in a negative manner.
Whatever it is.
Yes. Now you are
Therefore,
also
now,
saying I am to go again for challenging this.
because now what they will consider, what tribunal will consider now? If we say that the tribunal has relegated its duty or responsibility to the authority,
Yes.
then
Now,
we will ask the tribunal to consider again.
again on merit. Now subject to correction, my lord. It is a,
Then it becomes the same thing. That is what we are saying.
that will be-
Either we direct or you challenge this order. It is the same thing.
Your lordship may take note of the your lordship held on in one of the matters. WPST, my lord, 214. It will be the futile exercise.
2-1.
It will be sending the matter for fresh consideration, challenging that order as your lordship can.
Yes.
It will be the futile exercise because the authority will take the has taken the view, and if I go there, then filing is again away.
No, that is a different case. Their fact was totally different. Their tribunal also decided against the petitioner. And the order passed by the authority.
It is the pendency of the writ petition.
Correct. No. The
Yes, yes. Paragraph 6-7. Kindly see that 215 today.
215.
Your lordship's court held. My lord held. 6, 7, and 11. During the pendency of the my lord got it.
It is in this compilation.
WPSC 215. And I'm giving again.
Huh?
Maybe ratio. But kindly come to page C, paragraph 6, 7. During the pendency of the petition, one impugned order passed. Paragraph 6. And there also by way of can, that order has been challenged before your lordship. And that is why your lordship granted me to file.
Passing of the order there, if we remember correctly.
Paragraph subsequently filing to the writ petition, respondent have rejected the petitioner application of NOC for following terms.
Correct.
So therefore, some order has been passed. It could have been challenged by way of OA. Now the rejection order has also been put to challenge by way of application for can.
Yes.
And stand taken by and grounds urged in the present proceedings, both parties in the same, which urged before the tribunal and noted here. Now, taking L. Chandrakumar's case, your lordship held in paragraph 11. They have also said that this is not maintainable. issue of maintainability in the PJ is concerned, it is not a dispute. The same objection has been rejected. Relief grants certain sir. Therefore, your opinion that does not.
See,
Now,
the basic
I can-
fact in that case you will find in paragraph 14.
I've seen this.
Yes.
Now, I am on the ratio.
You, in your case, that is totally different. You have sought
leave it to the-
compliance of the tribunal's order. Here, the tribunal's order was required to be challenged because tribunal had accepted the state's reason that insufficiency of number of doctors can be a ground to reject. We said how it can be a ground.
That was the plea.
Therefore, we said this subsequent order means nothing. He cannot go back there because tribunal has already decided against him. In your case, that is not the situation.
Now, page 71 and 72, in one hand, the authority has given to understand to give the pension. Whether they can say in
So therefore, whether we relegate or you assail directly, it will have to be considered by the tribunal. Otherwise, we cannot do this. We remember now, after going through the judgment, I remember.
that short murder I have got till date.
Yes.
As your lordship murder. I was thinking, and in other judgment, 20 out of 24 judgment, relying on in those cases, petition is not maintainable, sending them. But I must be candid to your lords. I have checked it up yesterday night, all the judgments. In those cases, they are the non-appearing party before the.
That was the fact in the 2010 4 SCC.
10 4 SCC. And my Justice Canon division bench also, your lordship sitting with my Justice Canon.
Yes. Oh yes, we have passed one order. Yes.
Probably. I have checked it up all the 24 judgment of
So
different.
this does not help you. 215 does not help you. The facts are totally different. In fact,
and
at variance with your case. There, the tribunal's order was against. Here, you are seeking enforcement of that.
And one judgment I have got 2003 6 SCC held the tribunal alternative remedy by way of going to the tribunal with not in all cases no bar.
Only
in appropriate case, my lord can.
Hearing you because if we pass an order, detailed order, then
it can be done. 2003 volume 6.
Then,
Because in this case, tribunal ought to have been given, gone. But in Supreme Court,
the order is infructuous, basically. Now there is nothing remaining to be considered. So this order has to be challenged. If we pass an order dealing with all your submissions,
I got your lordship. So, I need think about the pensionary benefit, fundamental right, whether this can be molded by your lordship.
Pension is not a
You know? Right? Article 20.
pension is not a fundamental right. It's not a fundamental
right to life.
There are so many services without pension is correct. There is no fundamental.
That is the article 308.
Once pension is prescribed, then you have a right.
I have. It is a pensionary benefit matters.
Yes.
If not, does not. 30 article 300 is there. Otherwise,
He has shown us judgment that pension is not a
showing
fundamental.
all these judgment, my lord, which suits him.
Obviously, you are showing judgments which suit you.
It suits him.
And whatever suits us, that is the.
So I reject your lordship, my lord, because they are out of penny since 16 and 18. Whether it can be another 2 or 5 years. And tribunal is not taking any decision, my lord, mandatorily. Your lordship knows this. During this, my lord, 2018-19.
No.
After
Justice
Somitra Pal's
Justice Paul retired in
21.
23.
23, no.
22.
22. More than 3 years. There are directions.
Event came into force in 2021. Then committee was constituted. Then first committee, one of the member of the court retired. Then the other member retired. Then another Chief Justice assured that notification issued. Then only 2 applications were issued. And another applications out of time.
Yeah, one time but. And there was certain directions, different time by.
Central government is the authority. Now, president order has been issued by the President of India.
on the basis of advice by the government of India. Then we will communicate to the governor will issue the order.
2016 and 2018. Petitioner number Mihir, retired 30th June 2018. And Pulin 30th April 2016. Selection process of 1996, 95. Again restarted 2007 and appointment given 2009.
Will you take down?
Number 15. Item 15. আপনি আছেন স্যার? 15 আপনি আছেন?
16.
Item 16.
16. This is my application. I am filing affidavit, sir. Pursuant to my Lord's direction, my Lord, I serve. Yes, Lord. So he prepares the last. I've seen it. Hmm. And and yeah. शेयर करेंगे दे दिया फाइन कर देंगे
Getting capacity में end of 1980. You are appearing for the respondent.
Advice to appeal it because I necessity that the decision is proper. Decision that was done proper to the government.
You advise her to appeal.
I didn't appeal. Only your lordship that I should be here within the list right.
Yes.
And I'm grateful to him that he gives me an opportunity telling that on the tribunal platform.
You have also challenged the order.
no
No, I have not done it. But here I do have to subject to my lord's direction. I do. Lordship, Lordship is hardly for action.
No, you are appearing for the first day. That was for the purpose of an interim order. Not hurting. Just a minute.
I admit to all humility. Change are very happy.
We can please wait.
recovery of funds here and just so give us recovery at the time of having reject.
Yes.
Conditional first order, my lord. Passed by my lord, my lord. So, 16.
What is wrong with the order? Tell us.
First of all, my lord, the fixation of the page is totally wrong.
That has been rightly held by the tribunal.
And that has already been held by the learned tribunal.
Then the revised fixation is.
Therefore, we are saying what is wrong with the tribunal? That has already been decided in your favor.
And my lord, pursuant to wrong fixation, my lord, we excess amount, my lord, that is page 46.
That is?
That is page 46 of the writ petition.
No, 3 lakh rupees you wanted to recover.
Yes, sir.
That has been not allowed by the tribunal.
That already been recovered prior to that retirement. Nothing remains, my lord, for recovery.
The issue is only of the refund.
Issue is only for refund.
And refund can only be of a rightful claim.
And refund cannot be a rightful claim.
Refund can be a rightful claim.
Oh, that is already recovered.
Already recovered. And this is held by the Honorable Supreme Court, my lord.
The refund is of only to be of a rightful claim. Insofar as the claim, the recovery was way back done in 2013 in 8 equal installments. Now that portion has become infructuous. Now, insofar as the second prayer is concerned, with regard to the fixation of pay, that was in our favor. That was never challenged by him by an appeal. Now, their only relief, what they have been granted by the tribunal, is of a refund of money which was never belonged to them. It is their case that the revised fixation of pay should be set aside, which was never done. Their prayer was rejected. Now, in 2012 to 2014, their money was already recovered by us. Now, what they have sought, refund of those amounts which was already been recovered. Now, the error which is apparent on the findings, insofar as this portion is concerned, is, my lords, refund could not take place for the amount which is never belonged to them and which is not a matter of right. Refund can only take place which is a matter of right to them. That's what the humble submission, my lords, is here.
Supreme Court judge.
He was working on which post?
My lords, if my lords may kindly have a look at the
He was working on which post? Don't tell us.
Yes,
page.
Group B. He was working under Group B post. In 1999, he was promoted in an officiating capacity in a department of telecoms. That department of telecom was corporatized in BSNL in 2000. And in 2010, he was
giving us the entire history.
Yes,
We don't want to know the entire
Yes,
history. We are asking
Group
you
B
on
post.
the date of which
Group B.
recovery was made. He was on which post?
Group B.
B for Bombay.
And this was how many years prior to his retirement?
It was just a year, my lords. It was in 2000. He retired in
the date of his attaining age.
I'll just give it, my lords. He retired in 31st July 2014, and the recovery was happened between August 2012 till March 2014. Just a second. Judgment.
And he filed the OA when?
In 2013, my lords.
13 itself. So there was no interim order restraining the.
Yes, my lords. There was no interim order. Just a second. If my lords may look at their prayer.
Yes,
the prayer is at the page 2 of the improved order.
The prayer.
Yes, my lords. The first part becomes infructuous, the second prayer is rejected, and the third is allowed.
So third could not have
First
been.
part becomes infructuous.
The first part, my lords, when they have challenged the recovery notice of
How
A1.
it has become infructuous?
Because, my lords, that recovery was already been taken, my lords. So therefore, no issue of recovery at all arises. There was no stay order.
When he filed the OA, it was
In
still being,
2013, my
it
lords.
was still being recovered.
Exactly. But
So therefore, once he has approached the court,
yes, my lords,
his right becomes contingent to the proceedings.
My
How
lords,
can it become infructuous?
I bow down for that, my lords. But insofar as the recovery,
Infructuous is not the appropriate word.
my lords, in 2012 onwards, the recovery already
Not a
initiated.
situation which has arisen which cannot be turned back.
Yes, my lords.
Therefore, it cannot be said that it is infructuous. It is a situation which the tribunal has turned back.
Yes, my lords.
Number 1 and 2. Item number 3. Item number 4.
You don't have the file. You want the brief. Brief. There's so many authorities and respond number.
Two. But a delegated authority is a CMOH.
Tell us one authority.
Respond number 2, Director of Health Services.
Director.
Respond number 2.
Director. Respond
Director
number
of Health Services.
My lord, another thing that he was receiving the provisional pension. That will be continued.
Obviously.
Obviously.
We are only, he is not receiving provisional pension. He is not receiving provisional pension. He is receiving interim allowance.
Interim allowance.
There is no provision for grant of pension. It is an interim allowance, maximum 2/3 of the pension amount. That we are not interfering with that. हाँ भेज देना send all to chamber, stipulate and send it. All three are in there, stipulate and send it.
Item number 16.
May I please, Milord? Milord, here the recovery order was passed at page 46 on 30th June 2012. From August, if Milord see page 46 for a moment. As per the revised fixation memo, which is at page 45A, issued by the SD Jadavpur wide order dated so and so dated 8/12/2011, the overdraw amount comes to rupees so and so, which is to be recovered with effect from salary of July 2012 in equal installments. Now, from August 2012, the monthly installment initiated. So there was no objection till that time.
Where is the wrong fixation?
Yes, my lords. The wrong fixation is at page 45A, which is the revised fixation. They have, if my lords may see, page 45A. 8 December 2011.
We are asking you where is
Yes, my
the
lords.
wrong fixation, not
Wrong
the revised
fixation,
fixation.
yes, my lords. Then I'll show it from the impugned order directly. My lords, if my lords may see at page 4, their submission. If my lords may see at page 4 of the impugned order,
Where is
which
the
is
fixation
7th.
order? Where is the fixation order?
Well, is that fixation order of 2002 is not annexed, but it's there. in the-
2002.
Yes, because it's of 2002, which, if my lords may see,
It
sixth
does not-
line from the bottom.
It does not form part of the record.
My lords, here we haven't filed it. My lords, in CAT was they'll have.
How it can be? That
Lords,
must-
7,000. It's mentioned here. It's their statement, my lords. It's that the applicant sought
We
a
want
stay
to see the order. We are not concerned
of
with what the
2002.
tablet has recorded.
My lords, that is not part of the record, my lords. That 2002 pay scale is not part of the record, my lords. That incorrect. But it is for
Starting. It is of 2002 or 2004?
my lords, it is of 2002 because he was promoted, he was regularly promoted in 2002. So there was a pay fixation, which was of 7,500, 250, 12,000 under CDA scale. Now, it was his case that on 30th April 2004,
7,500 to 12,000 was the corresponding was given at 1188.75 to 17,275.
that's his corresponding to IDA scale.
Yes.
Yes. Well, it's what he
This
says.
is the scale which according to you
His
was wrong.
No, well, it's,
What was?
yes, my lords. The applicant sought his pay in CDA scale, which was rupees to be revised and my lords, the upper one, which is 7,500 for 250, that was incorrect, my lords.
No, that was CDA.
Yes, that was CDA because he never came into IDA. He came into IDA only in 2006. It was his case that he switched into IDA on 30th April 2004, but that has been rejected outrightly by the tribunal. So he was under CDA.
So according to you, this 7,500 to 12,000 is undue.
According to me, my lords, he was under that particular pay scale and he was drawing off rupees 8,500 as the basic pay scale. So that was the actual amount. It is mentioned also here, my lords.
Basic pay scale.
Yes, my lords, that's the basic.
What do you mean basic pay scale?
That is what the
basic is 7,500.
Yes.
How are you saying 8,500?
7,000
Of the scale, basic is 7,500
Yes,
and
7,000.
maximum is 12,000.
Yes, so under that he was drawing 8,500.
So he was in this scale,
Yes, that's what
7,500 to 12,000.
Yes, my lord, that's what I'm saying.
And this was
Sorry, my lord.
ultimately this was found to be undue.
This was found to be incorrect.
That is why we are saying
Yes,
undue.
my lords. Yes, my lords. Yes.
So the office order fixing him in this scale is of 2002.
Yes, my lords, which was rectified in 2011 by order of 8 December 2011.
No, we don't think that you are correct.
My lords, if my lords may say page 45A for a moment. That's the fixation of pay. That my lords will get it. If my lords may see the column left-hand side.
45A.
45A is the typed copy, my lords. That is the legible copy. Yes.
The pay fixation has been done by an order of 16/3/2004, not 2002.
16.
There was a communication by the ministry
This is what they have in fact said. it,
For
Malad.
giving the replacement scales, that communication by the ministry is of 2002 and fixation done in 2000. Sorry, sir, you go to your chamber. This is not the consultation place.
I'm so
Not
sorry
today.
because they have themselves mentioned it 16/1/2002.
We are asking you a question and you are asking your client.
No, Malad, I'm so sorry for this, Malad.
And you are saying it's not part of the record.
Malad, it's not part of the record here before they will
And you are relying upon the observation made in the judgment which you have challenged.
No, I'm relying
Show
on
us the facts.
No, Malad,
Very unique arguments you are making.
Malad, I'm so sorry.
It is an order under challenge by you and you are relying on the facts stated
Malad,
therein.
I am only saying their statement.
We are asking you.
Yes.
You are very much in the proceedings. You have filed a reply.
Yes, Malad.
What is, you are the person who has given the scale and you don't know. You are relying upon them.
16 वो reply का record लगाना चाहिए. Malad, what we can do is, Malad, because there are our affidavit.
Please come to page 39, sir.
Yes, Malad. Record में लगाना. Yes, Malad.
Just read it from the.
Yes. Introduction of IDA pay scale with effect from 1/10/2000. This in replacement of existing CDA pay scale for executive group B. Yes, Malad. Now, this is the in pursuance of Ministry of Communication, Information Technology, Department of Telecom, letter dated 6, letter date so and so, 28 July 2003, the IDA pay scale in replacement of existing CDA pay scale for the executives of BSNL effective from 1/10/2000 will be under. Now, this is the.
Look at serial number 2.
Yes, 7,000. Yes, Malad. Yes.
If you have bothered to go through the brief, then you would have shown us.
Malad, this is the pay scale of 7,500.
So his pay is within that scale.
Malad,
now you said his scale is within that. His pay is within that scale.
And at the material time, Milord, he got
Malad,
4 increments.
No,
More
Malad, let me just answer it, Malad, here straight away. There is a CDA pay scale, Malad. And here, this is an office order which was introduced that all those who wish to come into the IDA pay scale, this is an opportunity where you will have to apply. Now, if my lords may see the next annexure, which is the office order of, which is of 44A. 44A, this is 30th June 2004. This is the opportunity, and here for BSNL, it came on 30th June 2004, which is 44A. Introduction of IDA pay scale. He wants to be, Malad, it is his case, he wants to be under the IDA scale.
You have not annexed the OA.
Malad, that's the difficulty. OA.
Milord,
let me just 44A, Malad. Introduction of IDA pay scale with effect from so and so. Now on 30th June 2004.
We have got the copies.
You file a writ petition without giving the documents which are required to be
I'm
given.
so sorry, Malad. I apologize.
The matter.
I apologize, Malad, for all this
Documents were
inconvenience.
there that would have helped the case
Yes,
to
Malad.
be adjudicated
Yes.
immediately. Milord.
Just creating ambiguity for no purpose.
Malad, insofar as the pay scale is concerned, that according to us, my lords, with all due respect, is no more an issue integra before my lords, because that part has already been rejected and they never filed an appeal. Issue is only.
What is it that you are recovering, sir?
My lords.
What is it that you are recovering? Tell us.
My lords.
And what you have been directed to pay back?
My lords,
What is this? What is the component? Tell us.
Yes, that is at para 8. What they are saying it.
Where is it? Show us.
Yes, come to para 8, my lords, para 8 of the judgment, where they are saying.
Forget para 8. What is it? This 3 lakh has been directed.
That's the incorrect excess of payment. Yes, my lords.
So where is the basis? That is what we are trying to see.
Yes, my lords. May kindly come to page 44A then.
You have not yourself seen and you want to address us. That is the whole problem. You're not gone through the order of fixation. Who has done the fixation? What was written by the fixation order?
That
Should
part,
they be made to suffer or should they not be made to suffer? That is the issue. And the order is not before us.
we'll file a supplementary
What
after.
supplementary? This is the way to file a writ petition.
The,
On every query, you will file a
no,
supplementary.
I apologize for this.
At least you should have filed the entire records of the tribunal. That is a basic thing that is required to be done. And two of you are arguing simultaneously. Everything unique is happening in this case.
I'm only assisting.
You are arguing. You started assisting, then you started arguing. Now he's arguing again.
No, because I did not
It is
file.
a-
Nine, after having duly qualified, Lordship. And he came up to the pace of 8,500, getting 4 increments. But these people, they introduced the IDA scale, my lord. They Lordship. Lordship. Wrong. Yes, my lord, I admit wrong fixation.
That is if you come to page 46, this is at page 45 and the typed copy is 45A. फाइल नहीं कर दो पकड़ा देते हो फाइल पे रिकॉर्ड नहीं चाहिए था सारा कुछ वो है मैं कल भी बोला था वो ही नहीं है कॉपी रिकॉर्ड में ये तो मिनिमम है यार रिकॉर्ड में लाना कल भी बोले थे वो होना चाहिए था अब रेट फाइल कर रहे वो ही नहीं है रिकॉर्ड पे नहीं है लेते हैं वो होना चाहिए। कोई इंस्ट्रक्शन नहीं। ठीक है, yeah. Well, it's the
What forms the basis of this
yes.
revision?
Well, it's because here we have found out after the irregularity, which is
Where is that? When you discovered it?
well,
What
it's
is the
we
basis?
well, it's the well, it's,
This is the revision order of 8/12/2011.
yes, well, it's
7 years after the grant.
yes,
Now, what is the basis?
yes.
All of a sudden, one day you come out with this, at the bottom you say pay and allowances above officer may be drawn accordingly and overdrawn may be recovered, please. So what is the basis that we are trying to understand?
Well, it's that we have if Malats may come to the impugned order, we have stated in our pleading is being recorded here at para 6, and I want to read that, Malats. Page 6, para 6, Malats. No, not the para in reply. Sorry. Sorry, Malats. Para 5.
No, it is 6. You are correct.
Say,
It
yes.
is in the course of an audit.
Counter affidavit filed by the
That
respondent.
is
Yes.
in the course of
Yes,
an audit,
yes.
that because that is mentioned at page 45A also in reference at
there's a
serial
rejoinder.
number 2.
Malats 6 is the rejoinder, Malats. 6 the 5 is the Malats. 5. Insofar as the pay fixation is concerned, we have said 0.7 at page 6. And 0.6 and 7. That headquarters letter dated 36/2004, CT days collect letter, the date of promotion, so and so, general this, the
We are asking you what prompted you to come out with the revised letter.
Yes, Malats.
We are not asking you whether what is the entitlement.
Malats, in so
What,
far,
when you gave it to him in 2003,
yes, Malats.
what prompted you to awake after 7 years that yes, there has to be a recovery and it has to be refixed? What was the basis?
Malats, because there is no counter affidavit in part of this record, but what I've been informed that there was an audit which went on.
That's what we are saying.
Yes.
Come to page 45A,
Yes, Manoj.
reference number 2.
Yes. As per order so and so, and endorsement dated this, and yes, audit of the yes, fixation this, and based on the audit, yes, but that audit report I don't
You are
have it.
saying nothing is there.
No,
It is very much written here.
that record is not there, so I didn't want to say anything.
This is written.
But that's the audit.
Page 45A, it
Yes.
says fixation memo number so and so, number
Correct.
so and so dated 29/3/2010.
Yes.
Of audit officer, PNT
Yes.
audit office.
Yes, but I don't have it.
Obviously,
Yes.
it is based on this.
Yes,
And
of
this
course.
is what has been said at para 6 at
Yes.
page 7.
Yes, Parasite based on
The
this.
senior audit officer, PNT,
Yes.
received by sought to observe that the pay of the applicant has been wrongly fixed. So on 8/2/2011, an
Yes.
audit report suggested that there was something wrong.
Yes.
And then you awoke from slumber and then you decided that he has to be penalized.
That was the. Yeah,
These are the timelines.
yes. Ma'am.
It has to be good.
Oh.
He is a Group D officer.
Group B. Group B. officer.
He was working as
It's Sub-divisional engineer, my lords.
DE. So how is he to be blamed for this, that you want to make the recovery from him?
Let's here the issue is definitely, there is no finding that he has to be blamed as such. But here the issue what it has arisen, for that matter, if it's a group C or group D employee, I would not have pressed it because the law has been settled insofar as the recovery of C and D is concerned, that is not permissible. But here the issue is that he has been a group B employee. There has been a mistake which is apparent on part of the petitioner, but that has been rectified. The issue is, had it not been rectified till today, my lords, I would have said I don't have a case at all because he's been retired. But in 2012,
in this fixation, what is his mistake? In this fixation, there is no mistake on his.
No,
this was a unilateral fixation of 2003.
No, after the audit, when the revised fixation has been put, so that means they have rectified their mistake and therefore the recovery notice was sent to him. Now that money which already initiated a recovery from August 12th, so that mistake has been rectified because ultimately it's a taxpayer's money because the money has to go.
So
it
who
is
made
not
the wrong fixation? Did you proceed against him?
Well, with
the
passed an order.
taxpayers' money, who gave this taxpayers' money to him?
This is a public organization, Malad.
Therefore, we are saying who gave this taxpayers' money to him like this casually
These are government
and kept giving it for 7 years.
this
Who is
has-
responsible?
Plus, definitely this is our responsibility, but the fact remains is that because
Taxpayers' money
as quickly it should be rectified, but here it has taken 10, 11 years. But fact of the matter remains that it has been rectified.
We are asking you a serious question.
Yes, Milad.
What steps have you taken against this person who has done it so casually? And for all those officers for 7 years who have not bothered to care to check whether it has been rightly done or not.
Malad, here the fact of the matter is that no issue.
Because you are right, it is taxpayers' money. Therefore, we are asking you.
Because of the family.
You can't deal with it so casually.
The officer sometimes comes and goes, they get transferred. Now, who has done it? Who has done it?
It is very easy to find out.
Now,
The moment you want, you will find
but
out.
ultimately, Malad, the money has been
All
came
those
back to
persons who were in the position of taking a decision in
Yes,
this
sir.
7-year period, you can find out in half a day. It is all there in your records.
But,
Proceed against them.
But ultimately, Malad, the money has came back to the organization that steps and that action has been taken promptly.
No, why have not proceeded against them? That we are asking. Somebody does it so casually with public money, then why have you not proceeded against them? This is a taxpayer's money.
Certainly, Malad, the steps should have been taken, but Malad, they've not been taken. But no, certainly, Malad, certainly not, Malad. Certainly, there has been a mistake, then that after all it has been rectified. But Malad, the difficulty is also not of but if such precedents, Malad, of if money will yeah, Malad, then that may not be a mistake. It will certainly be a blunder or something. It will be a that I apologize. There has been some mistake, but I don't think in off late such scenarios are coming into the picture. And now the concerned officers are all taking prompt actions, and they are sincere enough these days. Here, if my lords may say that this is now, my lords may say now this is also a decade-old thing, my lords. It's not a fresh thing. It's a decade-old thing, which my lords, if my lords may also note here that this Department of Telecommunication in 2000 was corporatized into BS. No, I'm telling because my lords, there is a change of then there is a restructuring of so many things goes on, and it mistakenly went unnoticed. Malad, no, Malad, if the issue is that if the recovery would not have been taken, Malad, that is the reason. Malad, that is the reason the law has been laid down, Malad, here. Yes, Malad. Malad, Messi. Malad, because the law, insofar as the recovery is concerned, Group C and Group D has been laid down that it can't be done. But here, Malad, if Malad may come to page 14 for a moment, Malad. Para 14 and page 423, para 14. We are concerned, if my lords are there, we are concerned with excess payment of public money, which is often described as taxpayers' money, which belongs neither to the officers who have effected overpayment nor to the recipients. We fail to see why the concept of fraud or misrepresentation is being brought in such situations. The question to be asked is whether excess money has to be paid or not, may be due to a bona fide mistake. Then I will come. Then possibly affecting excess payment of public money by government officers may be due to various reasons like negligence, carelessness, collusion, favoritism, etc. Because money in such situation does not belong to the payer or payee. Situation may also arise where both the payer and payee are at fault. Then the mistake is mutual. Payments are being effected in many situations without any authority of law, and payments have been received by the recipients also without any authority of law. Any amount paid received without the authority of law can always be recovered, barring few exceptions of extreme hardship, but not as a matter of right. In such situation, law implies an obligation on the payee to repay the money. Otherwise, it would amount to unjust enrichment. Then, let's come with para 15. We are therefore of the considered view, and that except few instances pointed out, this case was referred, and the excess payment made due to wrong or irregular pay fixation can always be recovered. If my lords may see para 16, my lords, I would say last 4 lines. In such circumstances, we find no reason to interfere with the judgment of the High Court. However, we order that excess payment made may be recovered from the appellant's salary in 12 equal monthly installments starting from October 2012. So, my lords, in this case, my lords may, if my lords may note that here the court has appreciated that eventually it's a taxpayer's money, and recovery of those amounts which are not an authorized payment or which is illegal, that can be recovered, barring, my lords, C and D, my lords, where my lords may know that the judgment of the Supreme Court in that Rafiq Masik judgment, my lords. Here, my lords, in this present case, my lords, the issue is of a refund today. What they are claiming is of a refund. And my lords, with all due respect, the refund comes with a first as a claim, and claim is a matter of right. Now, let's refund of a payment of an amount which never belonged to them, which cannot create any matter of right for them. So the prayer of refund without any finding, without any reason could not have been allowed, my lords. And natural justice cannot grant a refund, because the reason what is given is a matter of natural justice. At para 8. यही सब में तो फिर होता। ड्राफ्टिंग नहीं है, तो लिखाना था पूरा, वही रिप्लाई रिजॉइंडर कुछ भी नहीं है। No, my lords, that's the limit. My lords, I just want to draw my lord's attention at para 9, my lords, which is against this of the impugned order. Para 9 of the impugned order. And 10, my lord. As regards the recovery of excess payment as claimed by the respondent, it is a matter of principle of natural justice. It was the department who actually had fixed the pay on the officiating pay scale of the applicant. The role of the applicant in this fixation of pay in the wrong pay scale has not been specifically highlighted by the respondent. It is therefore considered not fair to recover the excess payment, particularly for a period which is of a very long duration. If it is found wrongly fixed, the department should have rectified it immediately. Therefore, recovering of excess payment running into more than 3 lakhs is considered not fair and would cause a. So, and now let's just kindly see the para 10 first two lines. The claim of the respondent in regards to the fixation of pay is dismissed, but do not allow recovery. This is completely contradictory to para 9, the first two lines, because at para 9, they say that though it is my fault, I have fixed the pay, which we have said it, but it has been rectified. The court allows the rectification, they allows the revised fixation of pay. Yes, Milot?
Getting that salary.
Yeah, yes. So revised fixation of pay, he said, yes.
After
it is
that, the court said, the tribunal
because because they said because they never switched an option. If my lords may see paras
that is not the issue here.
because they never went into IDA. They never.
That is not the issue here.
Yes, that's not the issue. But here the question refund. There is no finding on the refund. As a matter of natural justice, refund of an amount which
why the tribunal says natural justice?
Because of the only fact, because they say that for no fault of them, which I appreciate.
Any civil consequences is to be preceded by compliance with principles of natural justice.
Certainly, but insofar as a refund is concerned,
standard, this is a settled proposition.
But then, for that refund, this is not a compensation, This is
obviously it is not.
It is
Who
not
says?
compensation.
The tribunal says it's a compensation.
No, but what they, as a natural justice, for some fair compensation may be granted. But insofar as refund is concerned, they can't ask for amount what
you are recovering from an employee, you will do without any show cause. One fine day, you will start making a recovery. Not even informing them anything.
I have passed an order on 30th 2012, but that order was only challenged in 2013 when the recovery was already initiated in August 2012.
Maybe they waited.
Yes, so that means there was no objection till that time.
It was within the time that they approached.
It was within the but
this is not written to the petitioner. This is an inter-office communication. There is no order sent to the petitioner. All of a sudden, their pay has been reduced. Where is the communication to the petitioners? Show us that, look, we have rectified your pay scale and from this month you will be getting this pay. Where is that communication?
We have any communication? We don't have it as
it's not there, sir.
It's not there,
It's not there.
It's not there.
You said you have informed, therefore we are asking you.
No, what I am saying it, what is my submission here is that the revised fixation of pay has been upheld. That has been upheld. Now
they are not challenging also.
Exactly.
Why are you repeatedly saying the same?
If they would have challenged it, then still the issue of fixation would have been opened as a, but here that's why I'm saying right from the beginning, I'm saying it. The issue is only of a refund, not of pay fixation and nothing. तो वही तो बोल है ना we don't insurance.
That is why we wanted to see your fixation order. There is no stipulation that it is subject to verification or recovery.
Yes, it's definitely.
And therefore, natural justice. That's why we asked you. Just think why tribunal has said natural justice.
Let's the natural justice
judgment that you are relying upon. You must have read it before you are placing it.
That's the issue.
That's the only thing which has weighed in the mind of the court.
Yes, my lords.
There was a clear-cut stipulation that the fixation is subject to verification and subsequent review.
Then, my lords, that is what I'm saying. If
There's
the,
no such stipulation.
if the fixation,
order,
if the exactly, if the fixation of play would have been set aside, and they would have upheld original fixation,
We are unable to appreciate this submission of yours.
my lords, I apologize, my lords. Let me try, my lords, different.
Yes.
Now the issue is of a refund. That's why, my lords, since beginning my argument is only, my lords, that what is before my lords is the only issue of a refund, not a fixation of pay at all, because they have never challenged it. Now the revised fixation of as a matter of fact has been upheld. Now the refund, what they are saying it that you refund those amount which is recovered. So refund will only come which as a matter of right, my lords, because something which is not belonging to him will never come, because
What is
because
new? This applies to every recovery. This is in every recovery.
well, recovery
Whether
is
it is
already done.
whether it
That's what,
is refund by you
yes,
or recovery from them, the same analogy
that
applies.
will only happen if the money is legitimate.
Sir, whenever
Yes.
it is recovered, it is illegitimate. It is nothing new. That is
No,
what
the
we are
finding-
saying.
No, my lords, what I'm saying, the finding today is that the money was not legitimate to him.
This is in every case.
Yes.
But in every case, even in Rafiq Masih, the case was the same.
Well, is that
What are you saying?
well, is that
Still, the court said that no, it has to be paid.
well, in a case if the recovery would not have taken place today, then what the court has said, you can't recover it from Group C and Group D employee,
Yes.
but Group C and Group D. But it has left out the other. But here it is.
Rafiq Masih is not the only case.
Yes, well, there are several judgments. That's why I said the law has been
Rafiq
settled.
Masih is relying on earlier judgments of
Yes, sir.
Sahib Ram and all these cases.
Yes, my lord. The law has been
So
settled.
therefore, Sahib Ram is perhaps one of the leading cases.
Yes, my lords.
And in that case, it has already been laid down that where there is no misrepresentation or fraud.
Yes.
This judgment says that cannot be the sole criteria.
My lord,
And because in the present case, there is a stipulation in the fixation order that it is subject to recovery. Therefore, we will not interfere. The judgment is clear. There is no departure from the settled principle.
my lords, the here
And you are relying on a judgment
my
which
lords,
is founded on a set of facts which are conspicuously absent in your case. There is no such a stipulation.
my lords, what it is said in the judgment, my lords, if my lords may see.
Please read para 16.
Yes, my lords.
Read para 16 of the
Yes.
judgment.
The appellants in the appeal will not fall in any of these exceptional categories over and above. There was a stipulation. Yes.
That is the only reason for excluding him from the above categories because there was a stipulation.
Mills, but here the
is
position
no
is,
such
Mills,
stipulation.
but here the position at the revised fixation of pay has been upheld. Now, once the revised fixation of pay
We don't know what you are trying to
is
submit
upheld,
again and again. You are saying this. We don't know how this helps you anyway. All considered in this. All the judgments. When did you retire? What is the date of retirement?
31 July 2014 जानते हैं.
My lord, he retired on 31st July 2014.
I know.
And when was the last
And the recovery
installment recovered from you?
recovery was ordered as I find on 36 2012.
When the last recovery was done? When the last installment was recovered?
My lord, recovery they say will salary from July 2012 to 2012 onwards it will be there. So after some recovery was made, he came to court. The deceased employee came to court. And of course, I admit I could not get it stayed. Their lordship said, after the case is over, we will get your money.
We ask you one simple question, you start giving the entire history. When was the last installment taken from you? What
Lord,
was
that
the
I-
installments?
That information I am not
How
having.
much, how much was the
When
installment?
he came to court,
How much was the installment fixed?
that of course I am not having. He came to court in May কবে এসছে May? May মাসে।
Is there any detail on record?
He came to court on
Is
May.
there any detail on
By that
record?
time recovery was, by the time the deduction was almost complete. He came on May 2013 and they
Yes.
said the recovery started from July 2012. One or two installments remained, I suppose, some or something. I cannot remember.
So 3 lakh was recovered in 1 year, within a year, within a year.
Milord,
3 lakh rupees was recovered within a year.
actually, within a year. He retired on 31 July 2014 and this order was issued on
Is there
recovery
anything
started
on record
Well, this is
regarding
not
the
part
recovery?
of the record, but I have a statement which I have been given that from August 2012 and March 2014 is the last installment.
March 2014 was the last.
Yes,
That is within 1 year prior to his retirement.
March 2014.
And he retired in July 2014.
Yes, Milords.
So at the fag end of his career.
And Milord, one thing that I have
Very well. When?
Milord, in myself strictly to the amount because Lordship has put me in bound jurisdiction. Milord, the Honorable Supreme Court in the case of Prafiq Mashi is very categorical to say that recovery from the employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is issued. That is barred. They say 16/1/2002. Actually, Milord, what they did on 16/1/2002, I already got 4 increments as a divisional engineer, Milord. Because though that was officiating after I have already qualified and I
Again, what we have stopped you, you are trying to
yes, Milord,
introduce.
I'm not transgressing there.
You cannot go into, you cannot
So I'm
travel
saying-
into that arena.
What I'm pointing, 16/1/2002 anomaly, they want to settle it 2012 after 10 years. That is prevented by this. They cannot do it.
That anomaly is of 2003.
No, 2002, 16/1/2002. Actually, the anomaly is there.
But the fixation is done in 2003.
Lordship, one thing I must have to say, though I am within my jurisdiction, that on 16/1/2002, this corporate body, still I was in government service.
Not, those issues are not open to you to argue.
Let's deeply
So the issue of recovery, which they are nothing else.
What they ought to have done, I should have been given in the idea scale 3 increments there. Point to point fixation, 4 increments. They have given
What is
only
the
one.
point of making such submission today?
Let's deeply obliged for a
Yes.
patient hearing, my lord.
Let's
So,
next.
I'm saying for my landed friend. 17.
The fixation was not. Due. This is not enough. Even this has been that they can want to such.
Item number 17.
Adjourn this
And
matter
for the-
coming Tuesday. Adjourn this, adjourn this coming Tuesday.
Yesterday he has taken action.
Oh, yes, sir.
Before vacation he has
Some
taken
problems
action.
coming.
He will do all the kindly fix.
Who is to appear?
Last chance. Last chance.
Who is to appear?
Yeah, Divyan Naran, he's my seniors. I'm responding. My fault.
2 घंटा बसे है.
I'm- My seniors.
Keep it here.
So sorry.
2 hours I am.
Not today, no order is being passed. Tomorrow remind us. Yes, not today. You don't intimate the learned advocate who is waiting in court, you don't intimate him beforehand that we are going to seek an adjournment.
Before vacation 3 or 4 days taken time. After vacation yesterday today.
18, my lord, I'm paying for not today on behalf of Sukumar Bhattacharya, appearing for the petition.
19.
My lord, I beg to appear for the petitioner in item number 19.
Yes.
My lord, I'm praying for a short passover. Mr. Shukumar Bhattacharya side is the senior. He's engaged in court number 36 right now. My lord, I'm praying for a short
Not today, no Passover. Not today. Come tomorrow. Yes.
My lord, item number 20
Yes.
is also the same matter. And
Same.
lawless matter.
Not today.
21.
In this matter, I am appearing on behalf of the respondents of the Mr. Sanyal, a senior advocate. was
Yesterday he had sought an adjournment. Today nobody is there. You are for the respondent.
Fair for respondent.
Yesterday.
On the self-same issue, after third application before the Central Administrative Tribunal, this appeal has been preferred. This for judicial review. And Lordships put the question to my learned friend, Mr. Sanyal, that how these 3 consecutive.
Yes, successive. How you can file successive? I asked him that if after this order they don't comply, will you file it?
They say that perhaps they will prepare another REIT application on the self-same issues and both would be heard together. But I don't know, we have not been served with the copy.
No, but if that is filed, that will be heard. Why this should be kept pending?
Yes, issue is the same.
Issue is the same. None appears on behalf of the petitioner. And asked him.
It
22.
I am for the petition.
22.
But he came running and said, Passover, he is in some court. Today he has run away. Today he came running. Today he. Yes. Where were you? The question will remain the same, whether today. Yes. Yes. Since substitution has been done, so then notice will be required to be issued. So this is substitution of the writ petition. Then notice is not. The writ petitioner has been substituted.
Substituted, my lord. She has died, my lord, because of pendency of 8 years, my lord, in the tribunal, my lord. The state did not file any affidavit in opposition. Ultimately, it was dismissed. My lord, the petitioner was appointed. My lord, in the year 1973, joined, appointed as a spray worker and
as a
DDT spray worker and
appointed or engaged
as subsequently appointed as a temporary.
So never appointed.
Subsequently.
Yes.
And continued, my lord, and when in spite of repeated approach and request, my lord,
In
that
73 he was appointed.
appointed
And when did he attain the age of superannuation?
60 years. So, my lord, actually,
when, which year?
In the year 2010.
30th June 2010.
Only 1 year, 7 months he could discharge his duty and then retired from service. One matter, my lord, for few days, my lord.
He joined on 16/1/2009.
16/1/2009, mile. After the state, my lord, lost in the Supreme Court, my lord, on 26/9/2001, the tribunal passed judgment in favor of these spray workers to absorb them. Then the government filed appeal before the Honorable High Court. Here also the government lost the matter and went to the Supreme Court. In this manner, my lord, 8 years, my lord, was required. And after that, after the judgment of Supreme Court, my lord, the Director of Health Services issued order to all the Chief Medical Officer of Health.
When the Supreme Court finally decided the matter?
In the year 2008, my lord.
8.
Then all districts of medical.
You are party to those proceedings?
Yes, my lord. My lord, Chief Medical Officer of Health, my lord, the order of the tribunal was those DDT spray workers who 50%.
Have you filed a reply?
Has not filed any affidavit in opposition.
Because so far as tribunal order is concerned, the tribunal rejected the application on the ground that under Rule 36, the government has no power. 8 years.
My lord, Nimachandra Chatterjee is squarely applicable in this case.
Chatterjee's case is different. Because that
same.
was working in a post. There is no such post.
No. In Nimachandra Chatterjee also after regularization. After regularization, there was shortfall. Before regularization,
You would like
there
to
was
see
no
the
post.
facts. We want to see the facts. If you want to file, you can file or we can proceed.
Yes. I'll give you time to file.
You file it because this is a very glaring circumstance. Working since 73 and 2009, you regularize, 10 he retires and you say nothing.
And ultimately died.
Regularization is... Don't invoke sympathy. Sympathy is not going to help you. This court goes strictly by the law. Everybody is here to perish. What can be done? Yes. Let affidavit in opposition be filed with the
8 July. My lord, one similar matter, my lord, was heard by your lordship, my lord. Your lordship was pleased to, my lord, reserve the judgment, and on that date, the matter did not appear. Hiralal Ghosh, similar matter.
On that day, it did not appear.
Did not appear, my lord. If your lordship kindly, my lord, look into the matter. CAB, judgment was
What
reserved.
is the number?
Number at present, I do not have. Hiralal Ghosh.
You think we will remember?
Hearing ended, and it was CAB, and for a few days, it was a date was fixed, my lord, to pronounce the judgment, to deliver the judgment, but না না হয়নি তো হীরালাল ঘোষ আমি নাম্বারটা দিয়ে দিচ্ছি আমার কাছে এখন নেই এক সিমিলার ম্যাটার
Yes, call the next case.
Hello, sorry sir, I am extremely sorry, my lord.
No, we'll see. We don't know. We don't remember. In our list,
I
there is
will
no-
give the number, my lord, to the officers.
He's saying it was.
Item number 23.
23, I am for the respondent, my lord, applicant in the way.
Huh?
I am for the respondent, my lord, applicant in the way.
Yes. You are for the petitioner. What happened in the review?
My lord, in this matter, they have come before your lordship only on the point of jurisdiction, my lord.
What happened in the review?
Review? My lord, no, there is no.
One review bearing RVW number 376 of 24
It is the,
was pending, and therefore we directed for listing after disposal of the review. What happened in the review?
In the review, my lord,
Still pending.
I am really not aware, my lord. I'll have to take instructions, Lord. I tried to find it out, the review number from here, my lord. I failed on that day. Lord, it was adjourned about a month ago almost. So I couldn't find out the review number. May I check up whether the review is pending or not? Because, my lord, the question involved here is, my lord, the question of jurisdiction, the territorial jurisdiction.
nothing else.
Whether, my lord, Rule 6(2) of the Administrative Rules of 1987 confer jurisdiction upon the Central Administrative Tribunal to adjudicate a dispute which has admittedly arisen outside.
It is a settled issue, my lord.
In which review was filed. Decided and single bench can go. So we'll put on merits. Yes, proceed on merits.
My lord, it is a well settled law that Rule 6/2 of CAT Practice Rules 1987, my lord, that decides the place of filing application, my lord. And
Why he is the petitioner?
My lord.
Yes.
May I first try from the petition, start from the petition, my lord? Your lordship kindly takes up the petition.
OA, where is the OA? Which page?
Yes, the way, if I may first refer to. Your lordship will kindly find the original application, which starts, my lord. This, my lord, starts at page 14. And the statement of facts begin from page 20. Lordship will kindly find, my lord, page 20, paragraph 4B. The petitioner begins by saying that he initially joined NPCCL, National Projects Construction Corporation Limited, as welder in 1979. October 5, 1979 at Chukha unit at Bhutan. So, my lord, the beginning of his career was from Bhutan in 1979. The dispute is regarding, my lord, date of birth. The recording of the date of birth is the entire dispute. My lord, takes up the entire of the petition. I can place the entire petition and I can show that there is not one single sentence which seeks to bring jurisdiction within Kolkata.
Difference of 5 months.
Difference of 5 months. That it comes up finally. Seven. 7. মেতে হওয়া উচিত আমরা করেছি ডিসেম্বরে। Well, the question is, if your lordship has gone through the petition.
So according to you, according to the OA, he has not worked within this jurisdiction.
Not worked. He has not.
Where has he worked?
First, he started from Bhutan in his own pleadings. He started from Bhutan in 1979.
Yes.
He went to Silchar, from where he retired in 2016. In paragraph D, quote D, he says he retired from Silchar at page 21. And he says that on the date of retirement, that is just before retirement, the list of superannuation is published. He says he draws knowledge from there. That is his allegation in the petition. And Milord will also kindly take up paragraph 4E at page 21.
What is the order passed by the tribunal?
Yes, ma'am. It's an order of representation, for consideration of representation.
Then
I have to admit that it is a simple order for consideration of representation, but the whole point I am trying to urge before your lordship,
Observations are very important, my lord.
the whole point which I am trying to urge before your lordship, my lord, if the jurisdiction, if the territorial jurisdiction, the question, my lord, of admission of the complaint, the admission of the petition, my lord, shows that the learned tribunal was, my lord, satisfied with the on the question of territorial jurisdiction. Now, my lord, if the territorial jurisdiction is allowed to, my lord, continue, a person from anywhere in the country can now come up after retirement and can
so
open.
which tribunal he was required to approach according to you?
Lord, he could have approached, my lord, in Silchar, where the offense, in my lord, Bhutan, where the offense was committed, where the default
In
was
Bhutan,
committed.
there is a central administrative tribunal.
Therefore, he could have gone to Silchar, from where he retired, from where he found
Silchar,
out.
there is a central administrative tribunal.
My lord, Silchar, my lord, he has a Faridabad jurisdiction to him as well.
Huh?
He has Faridabad jurisdiction to him as well.
Faridabad.
Faridabad, where
So
was
from
the
Bhutan,
central
he can
office.
go to Faridabad, but he can't come to Calcutta.
Lord, the subject to correction.
Not correction. What are you trying to say? We are
I'm
trying to
my lord,
understand.
I'm trying to draw your lordship's
He is
line.
not worked under the jurisdiction of the tribunal. Now, where is the territorial jurisdiction defined? Show us.
If your lordship kindly takes up, in my humble effort, my lord, if your lordship kindly takes up section 19 of the act.
Yes.
And so, my lord, sorry, my lord, I'm not carrying I couldn't find a hard copy from the library. Lordship kindly takes up, kindly pardons me for this and kindly takes up section 19. And if I may read out. If I may read out, my lord, section 19.
Yes.
Subject to the other provisions of this act, a person aggrieved by any order pertaining to any matter within the jurisdiction of a tribunal may make an application to the tribunal for the redressal of his grievance. Now, explanation is provided. I should also read that out. For the purpose of this subsection, order means an order made by the government or local or other authority within the territory of India or under the control of the government of India or by any corporation owned or controlled by the government or by an officer, committee or other body or agency of the government or a local or other authority or corporation referred to in clause A. Now, subsection 2, every application under subsection 1 shall be in such form and accompanied by such documents as or other evidence and such fee in respect of filing of such application and by such other fees for service or execution of process as may be prescribed by the central government. And on receipt of an application, it goes on to state how the application will be dealt with. Now, my lord, the first provision, subsection 1, my lord, settles that, my lord, in my humble understanding, a person aggrieved by an order pertaining to any matter within the jurisdiction of a tribunal may make an application to the tribunal for the redressal of his grievance. Now, in paragraph 4E, he has said that he has made representations to, my lord, the offices at, my lord, Faridabad and, yes, Faridabad and Silchar. My lord, nowhere has he said, my lord, that the default has been committed or any representation, any order has been passed by any authority within the jurisdiction from anywhere within the jurisdiction of the Calcutta bench. That is my humble submission. Now, if your lordship kindly takes up, this is the jurisdiction is, my lord, provided in section 19 of the Principal Act, which should take effect, my lord, over the rules. Now, if your lordship kindly takes up the rules, which I really want to test my understanding of the rules.
We are still trying to see where is the territorial jurisdiction specified in the act.
If I may once.
We asked you that question, you are making so many submissions.
But what I am trying to submit before lordship is that, my lord, it says a person aggrieved by any order pertaining to any matter within the jurisdiction of a tribunal.
So therefore, within the jurisdiction of the tribunal means relating to central government.
Relating to central
State government cannot be.
My lord.
So we are asking you, where is the territorial jurisdiction defined?
The territorial jurisdiction is, my lord, by my humble understanding, my lord, subject to correction under this section will go to, my lord, Delhi for it is the order is passed by.
Where is the territorial jurisdiction of a tribunal is specified? The only issue you are raising is that there is lack of territorial jurisdiction. Only thing you have to show is where is the territorial jurisdiction. Apart from that, you are saying everything.
Of territorial jurisdiction, which should have authority.
No, where is the jurisdiction of this tribunal is specified?
Yes, so far I have found from the Administrative Tribunal Act, section 19 is relevant and section 22, if I may place, procedure and powers of tribunal. But apart from this, territorial jurisdiction specifically, I have failed to find. Subject to correction, I have failed to find. Paragraph 22, section 22, my lord, procedure and power of tribunal.
Yes, what part of the cause of action has arisen
My lord,
in West Bengal?
my lord, it is clearly stipulated at Central Administrative Tribunal Practice Rules 1987, my lord, at Rule 6/2, my lord. 6 sub rule 2, my lord. I can read out, my lord.
1967.
1987, my lord. It's clearly stipulated, my lord. My lord, may I read out, my lord?
Yes, 6-2.
6-2.
Yes,
my
we
lord.
have seen that.
Not
May I
withstanding.
respond to that? That is what I have to respond to, sir, my humble understanding. 6-2, my lord, your lordship will kindly see, if I may read 6-2 once. But place of filing application. An application shall ordinarily be filed by an applicant with the register of the bench within whose jurisdiction, 1, the applicant is posted for the time being, or 2, the cause of action wholly or in part has arisen. Now, provided that the leave, provided with the leave of the with the chairman of the applicant, the application may be filed with the register of the principal bench and subject to the orders under section 25, so on and so forth. Now, subsection 2, notwithstanding anything contained in sub-rule 1, persons who have ceased to be in service by reason of retirement, dismissal, or termination of service may, at his option, file an application with the registrar of the bench within whose jurisdiction such person is ordinarily residing at the time of filing of the application.
My lord,
So
then
that is
what's
where
wrong
it draws
with-
power from. Now, this is a question I have to address, my lord. This is a question, this is the whole question that I'll have to address. If your lordship now kindly takes up the rules are framed from the, my lord, preamble. The rules are framed under in exercise of powers conferred under conferred by clause D, E, and F of subsection 2 of section 35. My humble submission is the rules under the delegated legislation is not authorized to pass any rule or to issue any rule on the question of jurisdiction. If
Who
your,
has passed this delegation legislation?
your lordship kindly takes up section 35, section
Who has framed this rule?
It is framed by the central government.
And who are you?
But I am one of the authority of the central government who has been, I'm not an authority, I'm a PSU, the public service unit, who has been brought under the
Central government.
purview of, my lord, Central Administrative Tribunal by a later order.
What is this? You are not challenging this rule and you are arguing as if this rule has to be ignored.
What I'm trying to submit, my lord, this
You
rule
are
has to
not-
be read,
You have
my lord,
not
this
yet
has to be read in harmonizing.
dispose of the application as soon as possible.
Lord,
How
this has
much
to be
time
read.
was fixed? 8 weeks.
My lord,
What was the time fixed by the order?
But may I rely on one judgment, my lord?
Yes.
Judgment paper, copy. Take the দিয়েছে ये শাইনামুল বলে যে জাজমেন্টটা এইটা I may permit to rely on this judgment, my lord. But it is reported in, my lord, 2021 20 Supreme Court cases 267. আমারটা চলে গেছে If I may rely on paragraphs 47 to 51, 6 is dealt with here. May I please? Paragraph 47. Before parting, we would like to observe that in terms of Rule 6 of the Central Administrative Tribunal Procedural Rules 1987, an application before the Central Administrative Tribunal is required to be filed where the applicant is posted for the time being or the cause of action wholly or in part has arisen. The applicant in her original application has not laid any foundation as to how the such and such bench of the Central Administrative Tribunal will have the jurisdiction to entertain an original application filed by her. It appears that the applicant had chosen the Ernakulam bench for the reasons that she was permanent resident of Kerala state. The applicant was not posted in the state of Kerala on the date of filing of the application. The applicant has not explained how the cause of action either wholly or partly had arisen within the jurisdiction of the tribunal at Kerala. This court in a judgment in such and such was examining the filing of a writ petition before the Calcutta High Court for the reason that the writ petitioner would suffer loss at its registered office, which is situated within the jurisdiction of the Calcutta High Court. It may be stated broadly that language of Article 226 and Rule 6 of Central Administrative Tribunal Procedural Rules 1987 is similar. The court, considering Article 226 of the Constitution, held as under. Now, my lord, the judgment is, my lord, quoted here. If your lordship kindly turns to.
He is relying on 6.2, you are reading 6.
6.2 is also, my lord, 6.
How is
the
6
purview of
relevant for
6
your case?
The purview of 6 is
You
considered.
can't just read anything that you want. How 6 is applicable in your case?
Lord, 6.2 provides the Lord, it is an exception to 6. 6.2 provides an exception to 6. My humble submission is, my lord, if the cause of action has arisen long before, when he was already in service, my lord, a cause of action which has arisen in 1979 is, my lord, tried to be reopened. My lord, he is choosing forums. He has waited all through, my lord, only to choose his, my lord, suitable forum here.
And what was the relief claimed in that case that you are relying upon?
But we will kindly come to, my lord. Elite list was challenged.
Yes, that's all.
What I'm trying to submit before your lordship is, my lord, the general rule for, my lord, conferring jurisdiction is the
Yes.
place of where the cause of action arises.
Yes.
And not if this allowed, if your lordship kindly grants me one more minute, but if this is allowed, my lord, this will open a floodgate for fence sitters. So it will open a floodgate for fence sitters. So we'll be, my lord, sitting over there, right?
Land council for the
That may kindly be that may kindly be directed, man.
We are telling you, when we have said all right, why are you repeatedly? We are saying all right. Yes, next.
124.
My lord, for the applicant, my lord, I'm seeking most humbly, my lord, 2 weeks accommodation, my lord. The learned advocate on record, my lord, he is physically handicapped, and my lord, he has went to Bangalore, my lord, for health checkups and all, my lord, for 2 weeks.
This is the first adjournment.
Lordship,
This is the first adjournment.
lordship, that I'm not. My
Let
most
us see.
humble-
Here, reply is due to be filed. Opposition.
He was required to file a reply.
Yes, they took time to file the reply.
As prayed by Learned Counsel for
Then 25.
Well, I am for the petitioner. Well, on 21st of March, the Lordship pleasure was to direct the state to furnish the records of the case. Lordship may kindly have a look to the order dated 21st March, wherein, Lord, your Lordship, the only aspect that was lacking for the petitioner to get security tenure in employment, and he has been thrown off from employment after filing the application. So, my Lord, Lordship's pleasure was to, because they did not use this before the tribunal. For the first time, they have used this here, a sheet of paper, where they're saying that I have not worked for 240 days. Other parts are fulfilled.
Kindly excuse me, Maharaj. What for the records from Malda district there? Maharaj, kindly give me 10 days time, Maharaj, so that in the meantime, because of the election commission issued certain directions, they are busy, Maharaj.
2 months.
The 2011 circular, 240 days in a year, just hearing in the
I'm the petitioner. Devu.
Six.
26, my lord, I am for the petitioner.
Challenging, challenging the my lord, order dated my lord, 14 May 2024 passed by the learned administrative tribunal. My lord, this petitioner will file this application. Lord, 1st December my lord, 2021 my lord, division railway manager Katihar my lord, issued notification for selection of post goods guards my lord, 15% LDC quota. Then my lord, a written test was conducted. Then my lord, panel was prepared. Then my lord, sent the selected candidate for training. Then my lord, in the midst of the training, the administrative reason my lord, there is a cancellation of the entire my lord, selection process. Or if you lord see my lord, kindly see my lord, page 48 is the my lord,
The cancellation was put to challenge in the tribunal.
challenged by the my lord, the respondents my lord, challenge the
Obviously,
tribunal.
they put to challenge the cancellation of the selection process.
Then my lord,
They had emerged successful in the written test
yes my lord,
and they were undergoing training.
yes. And my lord, in the midst of the training my lord, there has been entire my lord, selection process has been cancelled.
So where is the order cancelling the selection process?
My lord, page 67 my lord. 17 April 2023. Hereby cancel on the administrative account. Press.
So all this selection was from amongst persons who are already in service.
Yes, my lord.
It was not a general recruitment.
No, no.
So what has the tribunal done?
Challenging this cancellation, my lord, respondent my lord, file an OA application, and my lord, order was passed by the tribunal my lord, 1st April 2023. Applicant is filed comprehensive representation and respondent number will pass seeking order within 30 days. Page 77 is the order passed by the tribunal, my lord. First OA application.
No,
Page
no,
70.
forget about first way. Now come to
Then, my lord, region order has been passed, challenging the region order.
Where is the region order?
Page, my lord, 70.
What
Lord,
is
challenging
the
this region order?
reason is
Yes.
this is a reasoned order.
Lord, this is my lord, tribunal compliance of the tribunal model. This speaking order has been my lord, challenged by the OA
Can
application.
you decipher from this order why it has been cancelled?
Lord, administrative reason, my lord, they have not disclosed, but my lord, there is a one of vigilance inquiry. My lord, that report was not placed, but the report is my lord with me. If your lordship,
So these facts emerged before the tribunal.
must before, but as my lord, department my lord thinks not to disclose
was
the.
it disclosed before the tribunal?
Not, my lord.
No,
No.
Not before the tribunal also.
Not before the tribunal also.
Then why the tribunal has said to take an exercise to separate the tainted
Tainted
from
and not.
untainted? How it knows that the process is tainted?
My lord, that
Unless these facts were placed before the tribunal,
The
how?
ground of challenge in our writ petition,
In your,
in my writ petition, before this honorable court.
you have also filed a writ. You don't want segregation also.
There was, in fact, after the tribunal had come to a finding that there was no material placed to cause interference, but then this could not have been done. Please come to paragraph 12 of the order passed by the learned tribunal. The internal page 27 of the
They claim to have served notice on you.
that
Lord,
notice was for
in-
discontinuation of training.
or as per my lord master circular of the railway, my lord, clause 13, my lord, Kalisi, there is a my lord, authority has a my lord, power to my lord, cancel if my lord, irregularity is found or malpractice.
Para 219.
No, my lord, this my lord, page 16, my lord, clause 13, my lord. Amendment to representation against panel. A panel once, my lord, may I read, my lord?
Yes.
Once approved should not be normally cancelled if after the my lord, formation and announcement of the panel, procedural irregularities or other defects are found and it is considered necessary to cancel the event such panel. This should be done after obtaining approval of the authority next higher than the ones who approved the panel. And the representation, if any, against a panel should be submitted to the competent authority within a period of 2 months from the date of announcement of the panel. However, authority
In the impugned order, impugned cancellation order, you have referred to para 219L of
Yes.
IREM Master Circular
that is, my lord,
30.
that is my lord, Indian Railway Establishment Manual. Kindly, my lord.
This is only specifying the competent authority.
Yes, my lord. $190.
How many days training they had done? A week, 10 days, how many days?
Page my lord 63, my lord, page 63.
Roughly 3 months as it appears, not 50 days, 50 days roughly.
50?
55.
কোনটা? নোটিফিকেশন পাইনি। 27 নভেম্বর 2018।
Should be more than 50 days. Should be more than 50 days. From 20th March that they started the training. Is it 20th March?
No, my lord. 10th March is the my lord starting date.
So the date of instruction for training was 27th of February 2023, effective from 20th March 23.
20th March. So 20th March to 23rd May.
Yes.
It's more than 2 months. More than 60 days.
That's cancelled, my lord, 17 April that has been cancelled.
Huh?
Midst of the training period, my lord.
Cancellation is of 23/5/23.
No, my lord. Cancellation is the my lord 17 April 2023.
April.
17 April 2023, my lord, page 67.
Oh.
Page 67 of the my lord.
Then what has been done on 23/5?
That's the purported reasoned order on remand.
Oh, so therefore it is not long.
No.
20th March to 27th April.
Yes.
17th April.
17 April.
So my first impression was correct that it is some days, less than a month. Yes.
My lord, similar my lord circumstances on the my lord CRPF recruitment, my lord division bench judgment of this honorable High Court. My lord, here my lord training was completed. Then my lord, as per vigilance report, selection process has been cancelled.
There is no report here.
Administrative reason, but my lord, report was not.
Administrative reason mean?
But administrative reason is, my lord,
What
there
is
was that
administrative
period,
reason?
my lord, inquiry was,
Whatever ADRM or DRM thinks, that is administrative reason.
my lord, if your lordship seen the, my lord, report, my lord, they do with the vigilance. Yes, my lord. খুলে দিন, খুলে দিন। My lord, they, my lord, think it is internal, my lord, there may be involvement of, my lord, any employee or not, they, for this. Yes, my lord, this should be, my lord, disclosed before the tribunal. Yes. Yes, my lord. Should be disclosed, my lord, before the tribunal or prior to, my lord. Yes, my lord.
Then without natural justice, how can you do this?
My lord, after the order passed by the, my lord, tribunal, their, my lord, first application, they have made representation, then, my lord, opportunity of hearing was given and speaking order has been passed.
So hearing was given to them.
Yes, my lord. That reason order they have challenged before the tribunal. Tribunal, my lord, set aside
There
that.
is no reason. The order does not contain.
They have, my lord, stated here that administrative reason, but they have not disclosed that there is a, my lord, vigilance inquiry, there is a report.
Yes, what
But
do you have to
actually, my
say?
lord,
Anything else?
my lord, division bench judgment of this Honorable High Court, my lord, their vigilance report was disclosed, but after training was completed, then, my lord, selection process has been cancelled. That I have, my lord, handed
But
over.
you have not disclosed. That is what we are saying. What prevented you from disclosure?
Yes.
You think that your officer is above?
Yes, that should be, my lord.
Even now, or you don't want to disclose? We don't. Just because your DRM writes administrative reason, it will not become a justifiable reason. Or any authority, whether DRM, ADRM, whoever it is, they will have to. The law is that the court has to be satisfied that there was sufficient reason.
Yes, my lord.
Yes.
On the contrary, it appears not from internal page 10 of the order that in a similar situation, although not arising out of the self-same process, but for the self-same post in Guwahati, an exercise was undertaken, similar orders were passed, court set aside, then they were allowed to continue. Please come to internal page 10
of the order.
of the order, paragraph 2.6.
Paragraph
2.6. Further, learned counsel submits that in compliance of the order passed by CAT Guwahati bench as referred to above, the office of DRM North Frontier Railways video office order dated 27th February 2023 passed an order to the effect that the impaneled candidates are entitled to be promoted to the cadre of goods guard in level 5 on the basis of selected panel published video office memorandum dated 2nd of July 2021 against 15% limited departmental competitive examination. By referring to the same, learned counsel would argue that in the present case, the Katihar division of North Frontier Railway failed to comply with instructions contained in RBE number so and so of 2019, and the order passed by the Guwahati bench referred herein above is squarely applicable to the facts of the present case. Thus, the impugned order is required to be quashed and set aside. Then learned counsel would I skip over not those.
So where is this RB 192?
RB 192 of 19.
এর মধ্যেই আছে অর্ডারের মধ্যেই আছে
Is it there on the record?
Not on record.
We'll proceed tomorrow. You get a copy. It must be there somewhere.
But I prepared a compilation of these circulars, not to the extent made
Is
available.
192 there?
It's not on record, but this is outside the records.
মার্কশিটের মধ্যে আছে
No, no. 192 is it there in that?
192 I couldn't find.
Because that has been referred. Perhaps that forms the
पेज
basis.
142 मतलब पेज इंटरनल ऑर्डर पेज 22 मिनट
It is a quotation. It's not there.
that RB 192 19 dated मतलब 11 November
Internal page
2019
there is a quotation.
yes
No, no. This is not what we are. This is relying on 192.
Yes, that's a quotation from the.
This is the order perhaps cancelling the Guwahati process.
Yes, there's that I have included in the compilation, but that's not the.
Please get 192. Get it from somewhere. It must be available online or
But
somewhere.
it refers to as it is referred to as 192 by 19, but that's the cancellation order.
But relying on that only, the Guwahati bench has proceeded that there is non-compliance with 192. That was your submission before the tribunal. So what is it that was required to be done? Did 192 contemplate natural justice?
192 says before cancellation there has to be a notice issue.
So let us see. That is a very vital.
If the compilation is on record, that's page 19 probably. এটা দেখুন তো এরকম compilation আছে কিনা।
Page
19 of a separate compilation of records that I have documents that I have filed probably.
You bring it tomorrow. You bring it tomorrow. We'll continue tomorrow.